My lord, I beg to. My lord, I beg to mention a matter.
Enough to upgrade. Please give your slip.
My lord, the next date fixed is day after tomorrow. If a lordship doesn't take it up tomorrow,
Tomorrow we'll take enough kalke diye di.
oblige lordship.
Transfer of proceedings. Transfer of
24. Section 24, I don't have determination.
assignment.
When? The extension. No, I don't have any notice of assignment now.
Matters are one matter is appearing and this matter has been assigned. If you lordship
Is an assigned matter, then I'll see. They can যদি assign থাকে then.
My lord, may I take my lord's leave to mention a matter?
Please wait. Expeditious disposal দিয়ে দিন. Lordship. Serially, I'll come, madam.
May I be permitted to mention for expeditious disposal matter?
Please give it. Expeditious disposal slips, write it and give it.
And this is very urgent, Lordship. Next date is.
Write it and give it. Expeditious disposal matter, what urgent? Next date.
My lord, may I have a
Lordship.
My lord, may I have a lordship's leave to mention for matter for urgent matter, my lord.
Please write your grounds of urgency and give it. Yes, madam.
Yes, my lord.
So write your grounds of urgency and give it. Yes, madam.
While we are permitted to mention item number 102.
102 extend right. Mention it for extension of interim order. Give a slip. It will appear.
Extension.
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 Is appearing item number 738.
Please write your grounds of urgency. It will be upgraded if I find that.
May I permit it?
Please write your grounds of urgency and give it. That is the practice. That is the practice I follow. Please write your grounds of urgency and give it.
Lordship, may I permit it? Two matters already Lordship heard and fixed the date of next date of hearing, but matter was appear in the list but not taken up. So I mentioned also
Taken up in due course.
Yes,
You mention it.
may I be permitted to mention for upgradation of item number 17.
Please write your grounds of urgency.
My lord, may I
Lordship, for inclusion.
Inclusion, please give.
My lord, may I be permitted to
Mention on matter for upgradation in lordship.
Write your grounds of urgency and give it. Sir, don't mention it. Just write it and give it.
my lord, may I be permitted to mention one matter, monthly list, item number 1603. No, for expeditious disposal.
Give it. Give it. Yes.
My lord, may I be permitted to mention one matter, my lord?
Yes.
My lord, this matter came up on 30th of January 2026. This is a specially assigned matter, my lord. My lord was pleased to extend the interim order, my lord. I had mentioned it on 29th of April, also the last 29th of April, my lord, for extension of the interim.
This week, Friday, I shall be taking up assigned matters again. It will come up in the list.
My lord, my interim order is not there anymore, my lord. It was till the 30th of April, my lord. My lord, may please consider, my lord.
You give a mentioning slip for extension of interim order, it will appear.
May I be permitted to
My
mention may I be permitted to mention, my lord, for extension of interim order, my lord.
Please give your mentioning slip, sir. It will appear. Mr.
I shall tomorrow the date fixed in the court below. Tomorrow is today is the last date for interim order. If it appear tomorrow, my lord, I'll hand it over the slip, my lord.
Hand over the slip, it will appear.
My permitted to mention for extension of interim order. My colleague
Yes,
Mr.
yes,
Somu
please
Chatterjee will hand
the
over the slip, my lords.
Yes.
My lord, may I be permitted to mention with regards to item number 900 of my lord's list, that is expeditious disposal of an application filed under.
Please give a slip that it is expeditious disposal. It will appear under the heading expeditious disposal.
Yes, ma'am. Item number 900, my lord.
900 expeditious disposal করে দেবেন দিদি নোট করে নিন 900 expeditious disposal hearing
Grateful, man. Grateful.
হ্যাঁ লিস্টটা কল করে দিবেন
My lord, we are appearing in item 1 to 4, my lord. A date
Who is
was supposed to
the
be.
opposite party?
My lord, if you recall, this is that matter where Mr. Mukherjee was leading, my lord, injunction on UK shares, my lord. We had completed our submission and date has to be fixed.
I know they are not there today. So let it appear tomorrow. Or
Right.
it will appear in the same day, not the same heading tomorrow. In their presence, I would fix the date because there's no point fixing in their absence. They'll again come and say we did not know about it, so we are not ready. Let them come tomorrow.
My lord,
If
my
there
lord.
is genuine difficulty, also they might not have been able to come.
Grateful.
My lord, grateful, my lord.
Lordship, I appear. This has come upon my instant, Lordship. I had mentioned it on Thursday, Lordship, for release, Lordship. The matter may kindly be released, Lordship.
Very well. Likhene. As prayed for by the petitioner, this matter stands released from this list in view of the present determination. Full stop. List the matter before the Honorable the Chief Justice for appropriate orders.
I appear for the resolution professional of petition number 1. So
Give your names.
I'm for the respondent number 4.
Your Lordship, I am appearing for respondent number 1 and respondent number 7.
Give your names.
Lordship, can I approach the regular bench, Lordship, directly?
It has been released. It has to go before the Honorable the Chief Justice
Lordship.
for appropriate orders.
I bow down, Lordship.
My lord, this matter was already disposed of by your lordship by an order dated 2nd April 2026.
Disposed of matter ta keno esche?
For correction, my lord. However, in the names of the advocate appearing, myself appeared and I was led by my learned senior, Mr. Shukrit Mukherjee. However, some other name appeared by error. So there's a correction only in the names of the appearance of the advocates.
Likhene. This matter has been mentioned for correction of the name. Correction of the name. Name of the learned advocate appearing for the petitioner as recorded in the order dated April 2, 2026.
This is short, my lord. Sir. My lord.
Your Lordship, this revisional application has been preferred by challenging the order impugned dated 5/2/2026 passed by learned Additional District Judge Navadip. Lordship, the fact remains in the learned court below. We are the actually, Lordship, my junior has been filed the same. Can is required. Lordship, I am satisfying your Lordship. The order impugned is lordship regarding passing of one occupational charge. Fact remains in the learned code below, the rent amount which has been deposited in challan is rupees 100. Subsequently, in the learned code below, the decree has been passed for eviction, over which one appeal has been preferred. And therein, the respondent has preferred one fixation of occupational charges. Now, the learned first appellate court has graciously been pleased to fix the amount of occupational charges to the tune of rupees 25,000 and directed to pay it since the passing of the judgment. Lordship, the judgment has been passed in the year 31st July 2017. Now, your lordship, if your lordship kindly consider the previous precedent and the fixation of occupational charges, what has been determined in prior cases, that should be not more than 10 times, 100 times. But herein, the market rate, valuation of the property, absolutely, lordship. But lordship, herein in the learned code below, they have not produced any material documents regarding market value of the said property, nor even submitted any other precedential that herein, lordship, I am challenging the said order impugned. I am referring some judgment before your lordship. Lordship, the area is, I am stating from the schedule of the 1 biga 7 chitak 1 biga 7 kathas 2 chitaks of land. Place is at Navadvip municipality under holding number 16. Rent amount has been 100 rupees. 100 rupees. Lordship, if your lordship kindly reduce the same, because your lordship, I'm referring 3 orders.
On the other side, my lord. Much obliged.
21, I am for the petitioner, my lord. I have challenged the order passed by the learned Debt Recovery Appellate Tribunal on 26th of February 2026. My lord, the order impugned Appellate Tribunal, my lord. The order impugned at page 38, my lord. Page 38. But cut short to the argument, my lord. I bringing the facts before your lordship that the one notice under section 13(4) has been served upon the petitioner. That on that ground he has to given the 5,27,000 rupees, and otherwise the property will be auctioned. Order of because, my lord, the 2-3 things has not been accepted by the Debt Recovery Tribunal. I have deposited 5,27,000. That is absolutely right, but the amount is about 18 lakhs. 18 lakhs. They have calculated. They have served in the year of 2023, and the calculation has been given in 2025. As per the rules, my lord, 13(4) will be valid for 60 days. As a that has not. But my lord, one thing is that I have already deposited whatever they have wanted. No, that deposit has not been considered by the. They have told me that deposit 5 lakhs. I will the property will not be in auction, and that has been deposited by me. But at least give me some liberty to agitate this point before the. Yes, yes, yes. At paragraph number 7. Paragraph number 7. Before the DRAT. That application I have not annexed, my lord. If my lord give me 1 day or 2 days accommodation, I will bring up those papers and submit before your lordship. Just one line form. My lord, one line order, my lord. One line I order. for lordship.
Twenty-three lawsuit, I am happy with the petitioner lawsuit, plaintiff petitioner. Last Thursday lawsuit, already I placed this matter lawsuit.
I could not hear the complete. I did not 22.
You are appearing in 22.
I can't hear. Am I audible to you? Yes, my lord.
देखिए 22 का देखिए.
Because as a court officer called, my lord, it is not.
Huh?
The plaintiff is the petitioner of your lordship.
Yes.
Necessary for declaration and injunction. Declaration title in respect of the property in question. Where, my lord, can you turn to page? The plaint itself, I am drawing also attention to the relevant portion of the where my lord, the plaintiff is claiming title by inheritance, and the defendant is claiming title by way of a deed purported to be executed on Dulal Bor. Now, my lord, as soon as they take their claim on the basis of that from the deed executed by Dulal Bor, I filed an application under Order 670 along with Order 2609 for the purpose of bringing the fact that Dulal Bor, prior to the execution of this deed, executed another document in favor of another person. I want to bring that fact in and also prayed for handwriting expert. Now, my lord, can you consider my application itself one?
Mr. Rai, you are very feebly audible, and at times your voice is breaking also. You come tomorrow physically. I am not being able to make out anything of what you are submitting. কিছুই বোঝা যাচ্ছে না.
So, no, my internet, there is some problem in the internet. I cannot also hear.
Voice is coming intermittent.
Yes, well, grateful to Lordship for accommodating me.
23 lawsuit, I am appearing with the plaintiff petitioner. Plaintiff file a suit for declaration and permanent injunction, and also file an application for interim order of injunction, order 39, rule 1 and 2. That was adding allowed ex parte lawsuit ordering portion lawsuit. Page lawsuit, page 21. Page 21. Ordering portion. That the interim injunction as paid for is hereby allowed ex parte in terms of the observation made above. Both the sides of the suit are hereby directed so as to maintain status quo over the common suit flow such and such, and presently existing nature and character of the status and pattern usage of the A schedule property described property will remain under dispute till next date. Thereafter, usual order. Lordship, my client made an application under section 151 of CPC for implementation of this injunction order by directing the police authority. Page 23, prayer portion, Lordship. On the above situation, plaintiff prayed that Your Honor may be pleased to direct the OC Sabang PS to enforce the injunction order, and the defendant cannot violate the injunction order in any manner over the suit plot and any other orders which may be deemed fit and proper. The Inukas PR lawsuit, that application was rejected, holding that the application under Order 39 Rule 2A is applicable. Lawsuit knows Order 39 Rule 2A. The scope of the Order 39 Rule 2A is different. After violation,
serve and come. The petitioner is aggrieved by an order dated February 17, 2026, passed by the learned civil judge within bracket junior division Not today. Not today.
Your Lordship, in this matter, I'm appearing for the petitioner, Your Lordship.
27.
27.
27, I appear for the opposite party caveat only. My lord, if it's my lord's pleasure to take it up tomorrow, I may be physically present. If your lordship wishes to take it up now, my lord,
Very.
just
Come on. Not today.
maybe deeply appreciate. So
32. I am for the petitioner, my lord.
31.
32. And suit for declaration, recovery of position, and injunction. During pendency of the suit, injunction granted. Now, at the stage of adducing evidence, the defendant started construction and filling down trees of the suit property. Now, before we filed an application 39(2)(a), before taking up the application, suit disposed of. Dismissed on the ground that non-joint of necessary parties. Appeal preferred. Remanded back. Open remand. Liberty to amend the plaint and adducing evidence. Now, petitioner filed an application to incorporate certain facts which happened during dismissal of the suit and remanded back the suit in appeal. What the opposite party did, they started construction. Now we make an application to amend the 39(2)(a) application to incorporate those facts. Language rejected the same, holding inter alia that during that intermediary period there was no injunction. So dismissed, appeal preferred. So unless and until appeal remand, no injunction, therefore that part cannot be incorporated. Now, my lord, fact remains, when the appeal remanded on 20 December 2023, thereafter, my lord, they have started unauthorized construction. So that part I am asking myself, why cannot be added for amendment of the 39(2)(a) application?
No, but Order 39 Rule 2A application was filed prior.
Filed prior to dismissal.
So that Order 39 Rule 2A application, how will you amend subsequent to the...
Because that was alive, my lord. That has not been disposed of. That is pending. 39(2)(a) pending, but should...
Why don't you file? Does it not give rise to a fresh cause of action?
Subject to correction, my lord. Appeal is the continuation of the suit.
Appeal is continuation of the
yes,
suit.
Therefore,
But the interim order, if it is vacated, interim order is vacated along with the dismissal of the suit, the interim order also gone. Now the interim order has been reimposed, or a fresh interim order has been passed.
Yes.
Therefore, this fresh interim order will give rise to a fresh cause of action.
Fresh interim order gives a fresh cause of action, my lord. But point is, when appeal is the continuation of the suit.
Appeal is a continuation of the suit, but the interim order passed in the suit is not continuing in the appeal. So therefore, that interim order will not be continuation of the interim order passed in the suit.
But my lord, the point is that that point has not been taken by the learned judge.
That is different. That point can be supplied by the High Court, but then...
Then you can pass the direction. I will fresh application before the learned court. If it is done, my lord, I do not appear before lordship. Lordship, kindly pass the order. I will make fresh application.
No, do you have any authority in support of what you are submitting?
My lord, then your lordship kindly... apparently I have seen, but I have not getting the support. Apparently.
Even I don't have.
Yes, my lord.
Come back tomorrow or day after tomorrow?
Lordship, day after tomorrow, my lord.
Day after tomorrow.
But praise the Lord. My lord, this is an application under the new motion or the expedite disposal of a divorce suit made by the petitioner wife. Lordship, the marriage was solemnized in the year 2019 and registered.
2025 match suit. What expeditious disposal of this?
Expeditious disposal as to why, Lordship, first today the husband, kindly have a look, appeared on 24th of April 2025. Thereafter, after 2 days, they
difficult to fix any time frame. I'll ask him to dispose this off as expeditious.
Time frame. Only time frame, my lord. Nothing more.
No time frame. I'll say as
Lordship,
expeditiously
that
as
suit
possible.
is standing at the stage of reconciliation proceeding
That is
as
why
well.
time frame I cannot fix. 2025
At least
suit
within
is
a
too
year.
early. This revisional application seeks expeditious disposal of matrimonial suit.
Learned Fast Track Third Court, Barakpur. Lordship, at least within a year. Otherwise, the lady is quite young.
I got item number 35.
Under item number 35, I am for the petitioner. Am I audible to your lordship? Hello. This is an application for expeditious disposal of a title suit, my lord. It was filed in the...
My lord, this case is a little different, my lord. The council will explain.
Yes. Yes, you tell me. He's not audible. Tell me. Yes, sir. Please go ahead.
Filed on 3rd of October 2019. Subsequent file of the defendant.
You tell me.
My lord, this is a
Expeditious disposal. I'm directing. What more?
my
do you
lord,
want?
this is a representative shoot under Order 1 Rule 8.
So?
This is a shoot concerning the mismanagement of an apartment complex, namely Diamond
Want
City North.
expeditious
My
disposal?
lord, there is something more. My lord, regarding mismanagement of the apartment complex, my lord. Now, my lord, what has happened? In this shoot, the defendants have appeared, but on the last, kindly turn to page 194, my lord. On the last 3 dates, my lord, the defendant has filed Hajira, failed to appear, and instead the court ought to have.
Sir, I can only pass an order of expeditious disposal. I cannot allow you.
My lord, kindly, no, my lord, I am not asking for that.
Making submissions.
My lord, what I am wanting is that my attendance be recorded, a specific order be given that my attendance be recorded, the defendant's attendance be also recorded, my lord. That is
What do you mean by that? I didn't understand.
my lord, defendant filing Hajira but not appearing in court, and
it is not recorded in the order.
No.
Show me.
My lord, page 194, my lord. Plaintiff is filing Hajira, not appearing, and instead the court, instead of granting, granting ex parte, court is just saying that for the ends of justice.
Not ex parte is a different thing. But you say they are not recording. It's recorded there. Plaintiff
The
files
plaintiff
Hajira.
files, my lord, kindly come to the first order, page 194. The plaintiff and defendant filed Hajira. The case is adjourned today for the ends of justice. My lord, they are not appearing.
Thereafter, none to move on behalf of the defendant.
My lord, they are not appearing.
In one order, he has missed their.
My lord, second order. The plaintiff filed Hajira and filed Wakalatnama.
Application seeks expeditious disposal of title suit number 812 of 2019, pending before the learned.
My lord, attendance be recorded.
Learned.
Learned Civil Judge, Senior Division, Second Court.
May I make one smell in supplement to what?
Yes.
My lord, may I make one submission just to supplement? Mr. Dotto has
Yes, sir, but
that
you
the
cannot
two
go on for the
things-
entire day. Your network has issues. You are not
just
audible.
seize the one in these two orders that my learned brother colleague has pointed out. The matter was fixed for the hearing of these applications, my lord.
Very well, sir.
The
Then you serve.
adjournment-
Let the opposite party come. Then we shall decide.
My lord, we are just praying that the time frame may be fixed for
My lord,
disposal
that
of
is
the
what I was
application.
going to do. You are going on making submission.
My lord, I beg your lordship's pardon, my lord. Just that prayer we have, my lord.
That this,
I was going to do
these
that only.
applications may be disposed of within this time frame, my lord. That's
Yes,
what
my
I.
lord. That
My lord, application under order 39, rule 1 and
rule 1 and 2 and
one-
order 9,
and
rule
order
6.
9, rule 6.
Yes. लिखो. लिख लें. Is disposal of title suit number 812 of 2019 pending before the learned civil judge within bracket senior division, comma second court at Barasat, comma North 24 Parganas, as well as applications under order 39
Rule 1 and
2
and order 9, rule 6.
order 9 rule 6 of the Code of Civil Procedure, comma 1908 pending in connection therewith. Full stop. Paragraph. Usual paragraph. There is an usual paragraph where you are directed to serve a copy of this revisional application along with order on the opposite party, because they should know I am disposing it of X party within a week.
My lord, a time may be fixed to dispose that.
Therefore, next, having heard the learned, it is submitted by the learned usual paragraph. It is submitted by the learned advocate appearing for the petition.
Objection has been filed, my lord. And my lord, order 9 rules. I'm sorry. Grateful.
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 Yeah.
Grateful. Grateful, my lord.
My lord, this application has been preferred, challenging the order impugned in connection with one partition suit before the learned trial court. Fact remains the suit has been instituted in the year 2016 and there are 30 parties in the said proceeding. And in spite of passing long lapse of 10 years, still now the said proceeding has been fixed in SRAD stage. Repeated so cause has been made upon the plaintiffs
That is.
Every this RERA registered project with 100 plus flat allotments is injuncted, and till in spite of my lord's repeated orders, now an order has been passed, but I don't have a single finding on merits as yet. Even this order, irreparable injury will be caused, not a single finding on merits. I know today there is no adverse order. No, I'm today here only to make a humble record. You will see the reasons that if it can receive some, otherwise I've come. This is kindly see the reasons at page 5 because there are allegations. Grateful.
চলুন হয়ে গেছে, তার একই জিনিস কতবার ডাকছে।
My lord, I am for the opposite party. I have already filed.
Nothing will happen. চলুন চলুন চলুন।
I am for.
Petitioner is not there. Why are you mentioning?
The first time I beg to appear on behalf of the petitioner. May I place 47? The first time, my lord, the presence of on behalf of the petitioner. I am. Lord, what happened in this case, my lord? I have deposited rent for 2 months. But without complying the succeeding 15 days of month, it is to be deposited. Keeping in the mind, my lord, the holidays there, my lord, August and September, page 91 may kindly be looked into, my lord. 61 may kindly be looked into, my lord.
Yes.
My lord, kindly see rent for the month of August and September 2025. My lord, I have paid. My lord, Puja vacation was there. My lord, no malafide. And on the basis of that, my lord, the Honorable Court was kind enough to reject my application, and my lord, section 7(3) was invoked. Well, that is why, my lord, I am praying before this honorable court. Now, lordship, kindly see, my lord, the impugned order which is enclosed in the last part of the petition, my lord. My lord, here, my lord, lordship was kind enough, page 2 at the bottom, referred one judgment of 17.1, 17.2 related judgment, the erstwhile act, my lord. The Honorable High Court in case of Sukumar Sarkar. Before that, my lord, kindly see the para above. The question lies whether the deposit of rent by clubbing the rent of 2 or more months is valid, proper, and in accordance with the provision of the law laid down as to deposit of rent. My lord, this was the, my lord, subject matter of the court, and Honorable Court was kind enough to adjudicate this matter, keeping in the mind, my lord, of the erstwhile law. And my lord, a judgment reported in this regard, 1984 to Calcutta LJ 269. Here, my lord, referred section 17.1, and my lord,
the section 17 is perimeteria with section 7.
Not, my lord, the
Yes.
not entirely, my lord. Lordship, kindly
this provision is perimeter.
Kindly see, my lord, the section interest rate 8.13, 10%.
The perimeteria means the main flow of the section.
My lord, to some extent, my lord, we used to, my lord, consider the perimeteria, my lord, in the true sense, my lord, it is perimeteria.
It is in
equal,
the
my
true sense
lord.
perimeteria. Merely because some interest portion has been increased, it can't be said
At
it is
least,
not perimeteria.
at least, my lord.
The object is perimeteria. Yes, of course.
Yes, my lord. What is more, my lord, on the basis of this, my lord, Honorable Court was kind enough, my lord, to struck out my defense. But am I a defaulter there? What I have done, my lord, certainly.
When did you deposit the rent? The puja vacations were not in August and September.
Immediately after that. But keeping in the mind, maybe I will be missing. I have deposited it. There is no mala fide. Bona fide was there. I have done that. And my lord, I am ready and willing to deposit once again, my lord, but I have deposited already. As it appears, page 61, my lord, it seems, my lord, that I have deposited.
61 you have deposited
Yes,
for
my
which
lord.
months?
Yes, my lord.
August and September.
Yes, my lord.
August and September you have deposited in September.
Yes, my lord. My lord, kindly see rent of other. Lordship was kind enough to observe, my lord, in the court below that clubbing to rent altogether, that is the only, my lord, the hurdles before the court, and on the basis of that, court was kind enough to, my lord, invoke section 7.3.
Page 61 and 62 are the same thing.
My lord, 62, my lord, yes, my lord. Same thing. Then, my lord, October, lordship will find page 63. My lord, regularly I am paying, my lord. Here I have committed one bona fide mistake. My lord, I am not defaulter in any manner whatsoever. My lord, section 7.3 says whether I am a defaulter. My lord, I am not a defaulter at all, my lord.
Right. So,
at least, my lord, kindly protect me for the time being.
Your next date is when?
Next date cover. বলো দেখে বলো আরে দেখে নাও নি কেন But I'm sure
22nd of April was the last date.
Last date. 22nd of April was the last date for framing of issues. So, my lord, at least, my lord, the issue.
Tell me the date. Unnecessarily, I will not stay.
Or a date chot kore দেখে নাও নি কেন
লিখে নিন. This revisional application is directed against an order dated February 6, 20 6. लिखी दी। चलो next one.
52, my lord, I am for the petitioner. Lordship, this is an revision of the application is for expeditious disposal. The title suit is of 2017. I am the defendant number 5 in this.
You are defendant, you want the suit to be expeditiously disposed of?
Yes, your lordship.
लिखे नहीं। This revisional application seeks expeditious disposal.
Uh, 55, my lord, I am having heard the petitioner. My lord, expeditious disposal of the suit that is pending before the, my lord, learned judge of fast court, fast track court, additional district judge at Shialda. My lord, I am the defendant on that suit.
And also directed that the original admitted signature must be compared, which are not even part of the record. Milord, here, Milord, I joined with the issue, Milord, because this is a first appellate court, Milord, something which is devotes the pleading, Milord, cannot be considered.
Lord, my lord would kindly consider, my lord, the order impugns first. That the order number 47 dated 19th of November 2025. My lord, extensive submissions has been recorded. My lord, the findings are from internal page 4 onwards. My lord, the third paragraph. It is an undisputed factor that when the appellant is disputing the signature of Sogra Khatun, my lord, he is the plaintiff, as is there in Exhibit C of the trial court, then definitely to ascertain whether the said document has been signed by said Sogra Khatun or not, the same is required to be sent to the handwriting expert. But the question arises, what is the actual document of Sogra Khatun with which the signature as there in Exhibit C of the lower court and the plain Vokalatnama and tenancy agreement can be compared with? My lord, pause here for a moment. My lord, the plain Vokalatnama along with the tenancy agreement, my lord, this tenancy agreement was marked as an exhibit. It was produced at the behest of the defendants. My lord, thereafter, what happens is that the next paragraph, it is also admitted that Sogra Khatun had been permitted to observe Hajj. My lord, it was not even in the written statement, nothing has been come into the cross-examination. The court below has considered that it is an admitted position. Thereafter, my lord, they directed that accordingly, branch manager of Indian Overseas Bank, he has hereby directed to inform the court whether Sogra Khatun, wife of Sachin, had any bank account with the Indian Overseas Bank at any point of time. If there is any account of Sogra Khatun, to furnish the document containing the signature of Sogra Khatun, the account opening form. Thereafter, the appellant Mukhtar Alam is also directed to produce the passport of Sogra Khatun. Here, I joined with the issue because these two documents, it does not form part of the exhibited document. Section 45, section 73, there are n number of judgment which shows that it can be sent to the handwriting expert when it is an admitted document. Something which is beyond the record cannot be taken into consideration. My lord would just show the exhibit ones. I have page 53. The judgment of the trial court. The list of exhibits have been given. Page 53, running page 53 of my revisional application. Documents exhibited on behalf of the plaintiff. My lord would see the exhibit number 3, 4, 5, and the most vital is exhibit number 9. The report, the field note, where the commission has been held. This could not be, and moreover, my lord would also consider my application. What was the prayer that has been prayed for in the court below, which is page 85. Absolutely, the first appellate court is holding mini trial at this stage. Absolutely, correct. Whether the beyond the exhibited documents. Not even admitted. I even don't have any passport also. The court has made out a third case that I have gone to Hajj. Where from he is getting, I could not have understand. Not even in the written statement, not even in the cross-examination.
Yes. My lord, I am appearing for the petitioner. But I'm praying for expeditious disposal of one miscase that was filed in the year 2019 under Order 39 Rule 2A, my lord, along with the original title suit for partition, which is pending since the year 2018, my lord. I am for the defendant, my lord.
$65, my lord, I am appealing for the petition. My lord, here my prayer is, my lord, written statement which has been filed before the recovery officer DRT2 that was not heard out by the DRT2, my lord, and without hearing, date has been given one after another. By way of addition of party, my lord, I added as a judgment debtor number 2. After that, I filed written objection, annexing all the documents with my grievances, and that was not any steps has been taken by the recovery officer to heard out my lord, written statement, which has been filed, my lord, in November 2025. This is my only allegation, my lord. I am praying before your lordship to direct the my lord, recovery officer to heard out my written statement, which has been filed, my lord, on 10/6/2025. And after, my lord, hearing the written statement, my lord, anything, my lord, has been by the decided by the recovery officer, my lord, that is I ready to accept. But my written statement, that is, my lord, my prayer, my lord, that is filed before the recovery officer, my lord, debt recovery tribunal 2, my lord, that is my lord, page 16, last. My page 13, my lord, I file. Page 13. My lord, that is Advocate Abhishek Rao Chaudhary appeared CHI and file, my lord, rejoinder. Then, my lord, is directed to serve, accordingly directed to file. Page 13. Then page 14, my lord, I appeared, Linet Advocate the Vishwarup. My lord, written objection that was not heard out. My lord, I am praying before your lordship. Kindly, my lord, give some time, my lord, so that the recovery officer, my lord, able to. My lord, your lordship kindly requested the recovery officer to heard out my. And my lord, no, my lord, initiative has been taken by the recovery officer to heard out my recovery. Because I am the affected party, my lord, the judgment, my lord, holder, my lord, made
मोबाइल इसको साइलेंट करते हैं 84 आ गया My lord, I am appearing online for 84. I am appearing in person. This is a suit filed by the opposite party in 2010. They have taken several adjournments. Every day they are taking adjournment. Even today, till date, evidence is not complete. I am only requesting to expedite the suit proceeding. I am a cancer patient. But after every 6 months, they are giving the date.
This revisional application seeks expeditious disposal of title suit number 371 of 2010.
371T, my lord, 371T, re-number 371T.
371P.
T for Tata.
371T of 2010, pending before the learned civil judge within bracket junior division, second court at Barasat, North 24 Parganas. Full stop. The petitioner number 2, appearing in person, submits that is a patient of cancer and that the suit has been pending since long.
2010.
Full stop. Paragraph. Usual paragraph থাকবে আচ্ছা লিখে দিন কারণ উনি তো জানেন না since না লিখে having regard to the nature of the order proposed to be passed, prior service of notice along with a copy of the revisional application is not being directed. However, the petitioners shall remain obliged to serve a copy of the revisional application along with a copy of this order on the opposite parties within a week from date. Full stop. Paragraph. Having heard the petitioner number 2 in person and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket junior division, second court at Barasat to dispose of title suit number 371 of 2010 as expeditiously as possible and preferably within a period of 6 months from the next date fixed without granting any unnecessary adjournment to either of the parties. Full stop. Have you heard the order?
Yeah. My lord, only one mistake. Last line 371-7T. By mistake, you have only mentioned 371 2010. That is 371T.
T. Very good. 371T of 2010. He will serve a copy of this revisional
Okay. I don't mind. No. Okay. Thanks. Highly obliged. My lord, I used the website order.
Yes.
Order upload on.
Yes, website order will do.
Okay. Thank you, my lord.
I'll come back in 5 minutes.
Pasha, I am the petitioner. I am paying for expeditious discourse of matter. My lord, this is a partition should matter. 2019 matter. There is an application, one application are pending, my lord.
What is the application?
This case.
This case for what?
Order 39 rule.
Wait,
2A.
this revisional application.
Petitioner. But here, this suit for eviction filed by us. And the issue here is that the defendants have deposited the admitted area rent beyond the period of 1 month prescribed under the West Bengal Premises Tenancy Act. Well, the only problem is that I will not be able to assist your lordship with the page numbers. I have all the order copies, everything, but the brief is not with me. I have the soft copy of the petition as well. If I'm allowed to place the matter, my lord,
You can do it. Do it.
my lord, yes. My lord, this suit was, my lord, filed on 7th August 2025, my lord. Paragraph 3 of the revisional application, I've pleaded that. And summons was served upon the on the defendants, my lord, on 8th of September 2025, and they filed written statement on 23rd September 2025. On 23rd September itself, they had moved an application under Section 7(1)(a), praying that we.
When was the summons served?
Summon was served on 8th September 2025.
So within 1 month, they
Within
filed
1
the
month, they have filed an application, my lord. The learned trial court allowed such application, but the rent was not deposited.
after the application being allowed.
Yes, rent was not deposited. Now, my lord, on 27th October 2025, that is right after the puja vacations was over, on 27th October 2025, the learned trial court noted that since they have not deposited the arrear rent, their defense must be struck off because it was not done within the prescribed period of 1 month. Now, my lord, this order was challenged by way of a civil revisional application. My lord, the ordering portion of the revisional application 3864, my lord, is quoted in paragraph 6 of the application of the instant revisional application.
Page 46.
Yes, yes. Over there, my lord, and kindly comes to the paragraph where the coordinate bench has stated arrear rent was required to be deposited. My lord, 1 moment, my lord.
So he was directed to reconsider Section 7.
Reconsider because 24th October, my lord, was a local holiday. Therefore, the learned coordinate bench said that it should be reconsidered. And my lord, then the application was next heard on 2nd February 2026. And my lord, on that day, the learned trial court allowed their application for deposition of rent, but it was not done immediately on that day. Rent was ultimately deposited on 6th February. And the information slip from the learned trial court has also been annexed to the revision application annexure E. And the learned trial court,
because in any case, the current rents were deposited.
no, my lord, only the arrear 62,000 was
Current rent
deposited.
has not been paid at all.
No.
Then in that case, on that ground alone, Section 7172 will go.
My lord.
This revisional application takes exception to an order dated February 2, 2026.
And sorry, my lord, and the learned trial court gave a 12-day period to deposit the arrear rent, which is subject to correction, not permissible under the West Bengal Premises Tenancy.
Passed by the learned civil judge within bracket junior division, Kalyani, Nodia, in title suit number 171 of 2025, whereby the opposite party's application under Section 7(1) of the West Bengal Premises Tenancy Act, 1997, has been allowed, and the petitioner, and the opposite party has been permitted to deposit the admitted arrears along with statutory interest as well as the current rent in court within 12 days from the date of the order. Full stop. Paragraph. Mr. Chakraborty, learned advocate appearing for the petitioner, submits that the learned trial court has committed a jurisdictional
94 Lordship, I am appealing the plaintiff petitioner, Lordship. Lordship, fact of the case, Lordship, plaintiff filed a suit for declaration and permanent injunction, also filed an application for arrendering order of injunction. Initially, ex parte arrendering order of injunction was passed. Thereafter, defendant appeared and filed a written statements and contesting the said suit. Thereafter, Lordship, on 14th September 2016, I annexed the whole order sheet. Why are submitting the Lordship? 14th September 2016 issued a show-cause to the plaintiff why the injunction application not be rejected. Thereafter, Lordship, 14th November 2017, the said suit was dismissed. On that day, dismissed for default.
Yes.
14th November 2027.
For the dismissal that happened on 14th of November 2017.
Yes.
Was any order 9 rule 9 filed or
No,
any restoration
no.
filed?
On that date, defendant appear, plaintiff not appear,
Okay, so order
dismissed
9
for
rule
default.
4, whatever.
Thereafter, suit was proceeded.
No, if it was dismissed for default, how can it be proceeded with thereafter?
Lordship, I submit.
When was it restored?
No application for restoration was filed.
Then how can it be restored?
Thereafter, Lordship, again it was dismissed for default on 16th.
But how can it at the first instance be restored without an application for restoration?
Lordship, I submit that, Lordship. 16th.
That I have read. Don't read the dates. I have read that. I have gone through the order. You explain this.
Then my submission is the second dismissal order was clapped in the earlier dismissal order.
Only if there has been a restoration. Without a restoration, all the orders are being passed in a dead suit.
Dead suit. That was restored on the recall of the order date.
Without procedure, sir. How can it be restored without
Order 9 rule 9?
That order 9 rule 9 is subsequent.
Yes.
The suit was dismissed.
Yes. But when second time was dismissed for default, first order was clapped with the second order.
Can't be. The second dismissal is on your satisfying the court that you could not appear on that date. Prior to that date, why you could not appear? How have you been able to satisfy the court on that?
But that was not that was not only mistake of the plaintiff. That was also mistake
with the orders.
Lordship, page first of Lordship 2017 order, 14th September 2017 order, Lordship. And it's whole order sheet, Lordship. Got it, Lordship? September 14 November 2017. 14th November.
14th November 2017.
2017.
14th November I don't have. 17th May and thereafter 15th November.
No, no, no. The first dismissal order, Lordship, 14th November 2017. Got it, Lordship?
Suit filed.
Today is fixed for filing so cause
For
by the
default.
plaintiff. Plaintiff takes no step. Learner advocate on behalf of the defendant. Number such and such separately filing vogal number. Neither any so cause nor any step taken by the plaintiff on call. Hence, it is ordered. Hence, it is ordered that if the suit filed by the plaintiff is dismissed for default, thereafter so many dates was fixed for so cause. Thereafter, Lordship, second time dismissal order, Lordship, 16th.
So this 11th of July 2018 order, after this 14th of November 2017 order, this could not have been passed at all. Because these orders are passed in a dead suit. A dead suit is being restored after so many years. And what is the order? Where is the order of restoration?
Yes, restoration order, Lordship. 21st April 2025. 21st April 2025. Got it, Lordship? Having heard the learned advocate, I only relevant portion of the petition on perusal case record guided by the said principle. This court finds that the petitioner had no intentional laches and they cannot be made to suffer the laches of their learned advocate. Thus, this court finds the justifiable ground to allow the instant application under Order 9, Rule 9 CPC. Hence, that the instant miscase number such and such is hereby allowed on expiry disposal without any order as to cost. Let the original title suit number such and such be restored in original form.
This shouting will not do because the earlier dismissal for default still stares in your face. What about that?
Lordship, second dismissal order, first dismissal order is clapped with the second dismissal order.
How? How? What is your explanation? Please see 21st April 2025 order. 21st April 2025 order.
I have no knowledge about that order.
The explanation
about that order, I have no knowledge.
Then that is all the more dangerous. Your own suit, you have no knowledge about that order of dismissal of the suit.
Lordship, kindly see the second dismissal order, Lordship.
Second dismissal.
16 December 2022.
That was during
No,
COVID,
sir,
I have given
Lordship,
an
kindly see.
explanation.
16 December 2022.
Yes.
Today is fixed for filing so coach by the plaintiff. Plaintiff file a petition praying for time for filing so coach. On perusal of the case record, it appears that the suit is pending at the stage of filing so coach since 19 January 2017. As such, it is clear that the plaintiff has no intention to continue with this suit, and this is the perfect example of wasting the valuable time of this court. Let the time petition filed today is the plaintiff is rejected. Hence, it is that the suit and the same is dismissed for default.
What is this suit for?
Suit for declaration and permanent injunction. Plaintiff have no knowledge. Court also have no knowledge.
No, sir.
And also in the Order 9 Rule 9 application, notice was served, defendant not appear, and pointed out that fact also.
That's very good.
After restoration, I also filed an application for injunction. That was also injunction order was passed.
How soon can you serve and come?
Lordship, within 7 days.
Sir. this revisional application is directed against an order dated then again dismissed for default, and then that order dismissing the suit for default for the second time is recalled and the suit is restored to file. The court puts a question to itself as to whether, without recalling the first order dismissing the suit for default, the suit could be treated as one which is alive on the annals of court. Whether this is a point of law or not.
But in that
It is a point of law or not? Answer this question first.
that was a
It is a point of law or not? Please answer the question of the query. Please answer the question of the court.
the only point of law that the earlier dismissal order was a club
Of law or not? Yes or no? It is not or it is? Answer.
সেটা বলছে না ওরা 14 এর কথা বলছে No,
It is a point of law or not? Suppose in this case itself, I put this issue and this is framed as an issue and decided. Is it not a point of law?
and also the rejection of plaint. That
Rejection
was also
of plaint,
advisable,
that's a deemed
and
decree.
also lawsuit.
That also is a deemed decree. That is also appealable. If it is rejection of plaint, that way also if you look at, it is a deemed decree. That is also appealable.
No, in the 227, inherent, if the error in the apparent face of the record,
27, there is an inherent restraint. If there is appeal, I should not
No, sir,
entertain. You first satisfied me that that this is not appealable. There is no remedy of appeal available to you.
In
Satisfy
that
me.
order, Lordship,
Sir, you satisfy me on this. Don't argue unnecessarily. If you want time, you can come with better preparation, but don't argue and waste time. If you have answers to the query of the court, answer them. If you don't have answers, take time, prepare, and come back and answer.
Lordship, I'll give him 7 days time, Lordship.
As prayed for by the learned advocate appearing for the petitioner, list this matter after a week. এটা নিউ মোশনেই রাখবেন।
They have moved an application for stay of operation of the degree. Learned lower appellate court refused to grant and directed him to file the certified copy. But without filing the certified copy of the order, they have taken time after time, petition after petition, but no action taken for filing of the certified copy of the order. Instead of, they have filed an application before the executing court that they will bring an stay order from the first appellate court. But
Executing court has done what? They has stayed the proceeding, or it is proceeding?
no, still pending. Executing court still pending.
What are you aggrieved with?
Aggrieved with the order adjournment and without applying the mind of the application, time application, the or mechanically landed lower appellate court, my lord, granted time after time, so that I, being the landlord, I mean for bona fide need, so I am entitled to execute the degree and to get the fruits of the degree. That has been taken into consideration, my lord, so that a time my bound on time being
On disposal of the title appeal.
to dispose the appeal and to file certified copy within such and such. Within a period, my lord, already 1 year lapse.
Divisional application seeks expeditious disposal of title appeal number 76 of 2025 pending
Ninety-nine. 99 and 100. 99 and 100, Your Lordship, that matter, Mr. Tanmay Mukherjee, I'm being led by that right to sue survive of the tenant. My application for appointment of an administrator general has been rejected. It can be taken up tomorrow, Your Lordship, because Mr. Mukherjee has not come to court.
Tomorrow may not be possible. I'll fix a date because you are the only one who is to be heard.
Yes, Your Lordship.
কি হবেন নেই তো
Lordship is fixing any date. Now, Lordship is fixing any.
It will be indicated in the list. Maybe I'll bring it as a new motion and hear. হ্যাঁ কথা বলে নেবেন এখন তো কল করুন
Lord, I am for the opposite party number 2 in this matter, my lord, though the petitioner is not here. It's a very short matter on an MSME. The proceeding before the MSME is going on, my lord. It is stayed because of the order from the High Court. So, just that point is, it's a very short point because, my lord,
it's fairly at the top in the motion. It's fairly at the top at the motion. Any day I'll take motion.
Sir, this was already 4 times extension. The matter was fixed on the 20th of April, my lord. That date could not be taken up due to paucity of time, my lord. Just some precedence may be given. The very short point, my lord.
Today I will not be fixing a date. It's there fairly at the top as motion. I'll be taking up any day when I take motion, it will be reached.
Because, my lord, anyways, this matter they have mentioned it for the extension of the interim order, which is
on that
expired.
day I can take it up.
Yes, my lord. That is only that, my.
Very well, very well.
Grateful, my lord.
On that day you be ready, I'll hear it. When is the interim order going to expire?
It has already expired, my lord. End of this
interim
month.
order, এটা তো mention হয়েছে extension
Yes,
of
my lord. They
interim
have mentioned on the last day.
এটা তো mentioned হয়েছে extension of interim এ যখন দেবেন সেদিনকে শুনেন. Next.
Grateful, man.
For the petition. There is no caveator in this case, my lord. I have challenged the order passed by the Municipal Building Tribunal on 10th July 2005, whereby my Section 5 application,
25.
whereby my Section 5 application was rejected on contest with cost of rupees 10,000 against the my lord petitioner. Now, my lord, because of delay on limitation ground, from the date of receipt of the application, my lord, there is no delay. My lord, the lordship kindly come to page 19. The order of the special officer building against which the appeal was preferred. Now, lordship was fine from the top at the left side. The date of hearing was 26 April 2022. Now, my lord, no further date was fixed, my lord, for passing any order. And my lord, no copy of any order passed, if any, was served upon me.
What is the ground on which the tribunal dismissed your application under Section 5?
My lord, Ladder Tribunal came to the finding that I did not, my lord, annex copies of any documents for certain period in respect of medical treatment. And all my petitioner says that, my lord, a bunch of papers, my lord, was submitted to the Ladder Tribunal before the Ladder Tribunal. And Ladder Tribunal didn't go into all the prescriptions, my lord. Only few were discussed and, my lord, others were left out. And, my lord, from the date of receipt, my lord, I initially wanted to apply. I was not allowed to apply. The office said that unless it is approved by the mayor and council, well, approval is necessary. And, my lord, unless it is approved by the mayor and council, the copy of the application could not be accepted. Thereafter, my lord, on repeated persuasion, my lord, I was given a copy.
How many days delay was there?
Delay is from the date of application about 427 days.
No,
from
date of application means?
When I applied, on 20th July, I applied for the certified copy. My lord, I was told that unless it is approved by the mayor and council, but as per procedure, as they said, that it will be sent to the mayor and
Where
council.
is your application under section 5?
Survival application to me. The petitioner is very old man, my lord, having several problems, and my lord, he is suffering from various diseases. He could not pursue the matter properly, and my lord, the certified copy was given only on 5th September 23. And I filed the appeal on 13th, but there is no delay from the date of receipt of the application.
Receipt of the application and receipt of your filing of application will
Lord,
not serve.
it will appear from the order passed by the London Tribunal. It was recorded.
What is the provision under the KMC Act? How you are supposed to get a copy? Show me the provisions under the Act.
So judgment, Lord, I want to rely upon a judgment passed by the Honorable Justice
Show me the Act
Bhattacharya. Well, the London Honorable Justice Bhattacharya came to the specific finding that service of copy is necessary. Well, similar points has been discussed in this case, my lord. And in this case also, my lord, the Honorable Court was pleased to remand the matter, setting aside the order to the London Tribunal. Similar case. Similar issues were involved in this case. Under initiating proceedings under subsection O of section 400 and also section 416 regarding change of user. I was the complainant in that case. Actually, I had a right to get a copy.
It all depends on what you have written in your section 5 application. In your section 5 application, you have not said this, that you are not aware of the order being passed. Where is that case made out in the section 5 application? Because
for section 5 application, I have handed over.
Court will proceed
Lord,
to condone delay on the basis of your pleadings in the section 5 application. If the section 5 application does not contain this pleading, your government cannot improve that.
This was not happily drafted by the
whatever, but at least the minimum that is required should have been here for the court to develop later on. But here there is no scope of development. How will I incorporate facts? That I cannot do. If it is something on law, yes, the court can make up. But if there is a deficiency in fact, how will the court allow that, and how will the court manage that?
Or in that event, the London Tribunal ought to have granted liberty to the petitioner to make a supplementary application or like
where
that.
Is that prayer, and where have you said
all
that?
such cases
For
were
that also,
given
the
for the ends of justice.
tribunal will not presume that this might have happened. There must be a pleading before the tribunal, or at least a submission before the tribunal, and you have to show that you made this submission before the tribunal, which was not considered. Till such time that you can demonstrate any of these, I will also not be able to do anything here, because how will I find fault? I am exercising revisional jurisdiction. You have to show that there is a palpable error on the face of the record. How will I know that?
Lordship, can you consider the judgment passed by
the judgment proceeds on a different footing? That is why I wanted to see the application under section 5. This application is bereft of those particulars. Without the particulars being there, what will be the basis for the tribunal to assume jurisdiction to condone delay? Once it is delayed, the court becomes without jurisdiction. To assume jurisdiction, it has to come to a factual finding that yes, there are material on record on the basis of which I can condone the delay that has been occasioned by the appellant or the petitioner. Where is that material?
The cost has also been imposed upon the petitioner.
That is different. Cost may have been imposed upon, but then If the
without
court
any-
finds that it is frivolous, then in that case, it can be justified in imposing costs. Are you only aggrieved with the costs?
My lord,
Are you only aggrieved with the costs?
দুটোই ছিল। I have challenged,
That I understand, but then
but
without,
Lordship kindly, my lord, in
because
that
the,
event,
your illness ground has also been disbelieved by the tribunal, saying that you have not been able to produce any document in support of that. That is the finding, page 3.
that you Lordship kindly set aside the portion imposing the cost at least, my lord. Petitioner is very, my lord, old man, my lord, he could not be able to pursue the matter before the tribunal. He could get the petition drafted very well. And all these questions were required to be taken. I agree. My lord, I have said in my petition, my lord, from the order passed by the learned tribunal, my lord, it will appear when I receive
of 10,000.
10,000, yes.
So,
no, my lord, it is not possible for him, my lord, to, and this Lordship kindly do that for the ends of justice, my lord.
And what is it that has been asked to be demolished?
My lord, there are two, my lord, sanctioned car parking spaces. My lord, measuring about 430 square feet. And my lord, I was entitled to one car parking spaces to be measured 215, and another one 215. What the promoter did, he has, my lord, converted the total car parking space into 3 tenements, and my lord, sold to others. One portion has been given to me, and my portion has been reduced to 100. I was supposed to get, my lord, 215 square feet area. That is my main grievance before the time. And Lordship, Lordship, I come to page 19, my lord. This was first given after long
The
delay.
complainant.
Yes,
You
I
are
am the
the
complainant.
one of the complainants.
Complainant. Well, Lordship, I come to page 19. His copy was first given on 23rd August.
That is not the case. That is not the case in the section 5 application. This revisional application, the sales. serve.
May I take back the copy of
Yes,
this?
yes, judgment গুলো দিয়ে দিন। Next.
Lordship, 106, Lordship, I am appearing to the petitioner. The caveat is there, Lordship. Lordship, kindly fixing the date. Already I mentioned tomorrow morning also, and earlier also mentioned execution. Tomorrow morning I am also, today morning also already mentioned. Execution case was also proceeded, Lordship. Impugned order is section 47, the rejection of the section 47. Kindly fixing any date, Lordship. 11th is the date fixed before the executing court, Lordship.
11th May is the date fixed.
Lordship.
Very well, I'll indicate it. একদিন মোশন উপরে রেখে দেবেন এগুলো। মোশন গুলো একদিন কল করে দেবো, তাহলেই তো হয়ে যায়। Yes, next. মোশন তো এটাই নাকি? লিস্ট তো একদিন কল করলেই হয়ে যাচ্ছে। নেক্সট।
My lord, 115, I'm not able to listen courts.
Yes.
My lord, this is regarding the miscellaneous case number where 30,000 order was passed, 15,000 for the minor daughter.
Yes.
And 15. And the last date, some interim order was passed, my lord. I have served the notice to the opposite party, and both the notice are delivered to them. I think they have also submitted their wakalatnama on 17th of April. Opposite party has submitted wakalatnama.
There is nobody appearing for the opposite party today. When is your next date before the trial court?
My lord, mat execution case is 7th of May, this Thursday, my lord.
I'm just making it not today, maybe tomorrow or day after tomorrow I'll take up.
My
Because
lord, at least for
other side
my
is
lord,
not there today. There is a resolution not to pass
okay.
an adverse order.
My lord, for 7th of May, at least if I don't get any adverse order, I am fearing that, my lord. So
Won't get. Before that I'll take up. এই মোশন গুলো দেখে দিই কালকে বা পরশুদিন একটা উপরে রেখে দিই।
my lord, the matter was listed on 8th of April, but since 8th of April, my serial number has never come, my lord. So
it will come now.
Kindly, tomorrow, my lord, at least one stay order for next date, my lord. Otherwise, I will be in serious trouble.
I'll
I
pass
cannot
the
be.
order of stay if at all I have to pass in presence of the other side. Not today, maybe tomorrow. Tomorrow or day after tomorrow, whenever it is taken up, it should be taken up before 7th.
Oblige, my lord.
এটা একটা মোশন নিউ মোশনে দিয়ে দিন ওই ওনার 115 কালকে নিউ মোশনে দিন। দেখুন একটা অর্ডার রেকর্ড করে নিন। I am recording an order in your matter. Order record.
Well.
The petitioner is present in person through virtual mode, full stop. None appears for the opposite party, full stop. But how do I know that you have served? There is nothing on record.
My lord, I can mention that speed post article number, which is
No,
delivered
that will
both.
not do. I have to keep it on record. Somebody must be here to give it on by way of an affidavit.
My law clerk will be there. He will be submitting a printout of the tracking report, both the printouts.
Printout of tracking report will not do. There has to be an affidavit of service. Nobody is there. Anyways, the petitioner submits that service has already been effected on the opposite party in terms of the order dated March 27, 2026. Full stop. List this matter. However, since none, full stop, however, since none appears on behalf of the opposite party, comma, list this matter as new motion on Calcutta did this. May 5, 2026.
My lord, I am submitting in person. So affidavit of service, I may not be able to submit tomorrow, but printouts I can submit, my lord.
So if tomorrow the other side is there, then in that case, you may not be required to. If the other side is not there, then in that case, it will have to be. You have to arrange it because without affidavit of service, I will not be able to pass any ex parte order also.
Oblige, ma'am.
If you cannot do it tomorrow, do it day after tomorrow. I'll adjourn it tomorrow if you are not it is not possible for you.
I will oblige.
Next. আপনি কল করতে থাকুন না, আপনাকে দাঁড়াতে হবে না, যে থাকবে সে এসে আপনার জিজ্ঞেস করে করে কল করলে অসুবিধা হয়।
In the petitioner, my lord, in the same analogous matter, my lord, in the monthly list in 1094, my lord. Kindly take the matter on the same matter, an analogous matter, my lord. Matrimonial
1094.
1094, my lord. This is a
129 টা 10 once it is taken up, you tell me, both will be taken up together. ছেড়ে দিন, চলুন। Next. হলো তো 129 তো হলো।
My lord, I'm appearing for the petitioners. My lord, the fact is this: I'm a tenant on a property. Suit has been filed by the landlord. Plaint has been served through bailiff, not through court or not through the post. Bailiff report has not came. Previous to that, they have file an application under 7172. When I get the knowledge about this suit, court hold that you have served, you have not came within time, so your 7172 has been rejected. Now, my lord, once kindly come first order dated 26/4/2023, when the suit was filed. On the below portion, my lord, get it, my lord. My lord, get. Today is fixed for SR ready, plaintiff file Hajira, SR received without service. First recorded this. Thereafter, my lord, just the next page. Today is fixed for taking fresh step. My lord, even then the plaintiff did not take step. Plaintiff file Hajira, today is fixed for SR ready. SR is thereafter, my lord, kindly come once. My lord, kindly come to page number 26. When I get the knowledge through the
order dated 16 January 2024.
16 January 24,
Ah.
SR of the sole defendant receive as proper service. If that be so, why the belief has not been taken into consideration?
What
Why that belief has not been give the evidence?
It shows that you were served on 16th of January 2024. You had been served.
My lord, no service has been made. No service has been made. My lord, kindly come to the next page, 27/3/24. Just on the very first day, my lord, as per order 14 of the code, I should have to given at least 3 times on the first very day, first day. If I have served, if
You have been served.
if your lordship hold that I have served, well, I have served, then why the time has not been given on the very first day? Why the expiry has been made?
Time for what? Time for what?
My lord, if I have not appeared to the court, a show cause could have been made as per order 9, rule 9.
That's neither here nor there. What are you aggrieved with? You tell me that.
My lord, kindly come to page 26 once.
Yes.
After getting the knowledge about the suit, I have made this searching. My lord, kindly go through the date. It is on 26/2/2024. My lord, thereafter I get the certified copy of this plaint on 28/24. Before getting the certificate,
Go slow.
My lord, kindly once come at first page 26. My lord, that in the left hand portion, the date 26/7/24, it was made. On that very day, I get the knowledge. Just came to the very next page, 27. My lord, I have filed the application for put up on 1/8/24. 26/7, I get the knowledge. I make the put up on just very next day, 1/8/24. Thereafter,
Where do I get that?
my lord,
Which page is your
27, my lord, 27. I make the put up. And also in order portion, my lord.
It is on 30th of August 24, not 1/8.
30th is the prayer. My lord, kindly come to Howrah Court signature, my lord. And if, my lord, then my lord, kindly come to order dated 27/8/2024. (23/8/2024). My lord, it is a handwritten order. Now, my lord, once kindly come to page 17. When I have, as I have do not get the copy of the plaint, I have get the certified copy of the same on 28 2024. My lord, page 17 is started. My lord, kindly come to page 25, last portion where the signature has been made. The servicing person, my lord, 28 24, typed by. My lord, I do not get the copy previous to this. Now, my lord, once kindly come to order dated 17 to 25. I have filed the application for vacating the ex parte as well as show cause petition. That was allowed.
Where is your application seeking vacation, taking this to take off the ex parte board?
My lord, just 28. My lord, in page 29, para 2, I have stated all the facts.
All right, come back after recess.
My lord, along with this,
Come back after recess.
my lord,
Lordship, may I mention? My for expeditious disposal of the instant matter.
After recess, I'll take it.
This point.
The petitioner is not there.
Petitioner is
Nobody is there for the petitioner.
no my.
Very well. I have disposed of the writ petition. There were two adjustments which were impugned. So far as the first adjustment is concerned, since it is beyond 3 years,
Yes, my lord.
I have not entertained that.
My lord.
So far as the second adjustment is concerned, I have interfered with it.
Yes.
I have not granted interest,
Right.
but I have directed refund.
My lord.
And I have also said that the appeals
My lord.
should be disposed of within 2 months from date,
My lord.
because the appeal is still pending.
My lord. Grateful.
That is it. You will get the order on the server duty.
My lord. Grateful. Grateful.
Thank you. এটা কারেকশন করে তারপরে সার্ভার না এখানে
My lord, at first, my lord, kindly go through the orders once.
serve a copy and come. I am not satisfied, but
My lord, kindly,
serve a copy
my
and
lord,
come.
with this regard, I should have served. My lord, my lord, along with this, 1607 is the same matter. There is two tenants. One is upper, one is lower. Both of them service. And both of them has filed this application.
लिखे नहीं. The petitioner is aggrieved.
Indeed, Your Lordship.
তো আগে বের করে রাখছেন দিদি, জানেন তো টিফিনের আগেই তো মেনশন হয়েছে। তারপরেরটা কল করুন, উনি আপনি কল করতে থাকুন, ওনাকে বের করতে দিন। প্লিজ ওয়েট, লেট দি ফাইল কাম। চলুন।
134, well, I am for the petition, my lord. My lord, what happened, my lord, in the instant case, my lord, petitioner number, opposite party number 1 filed a preemption case against the opposite party number 2, relying upon a deed, alleged deed, which has been executed by the petitioner. Deed, the petitioner contention is that the deed which has sought to be preemption application, that was not at all out and out sale deed. It was actually it was the mortgage deed. By practicing fraud, opposite party number 2, registered the sale deed. That's why I have already made a complaint, written complaint before the executive magistrate, and on the basis of that, already an FIR has been registered. Apart from that, I have already challenged the said sale deed before the civil judge senior division, and that suit is pending. The learned trial court, what happened, my lord, in the learned trial court, when I made an application for addition of party, in the preemption application, the learned trial judge, my lord, rejected that my application on the plea that I am not necessary party in since, my lord, it's a preemption between the parties to the proceedings. My lord, but in the instant case, learned judge relied upon a judgment. I am bound by that judgment. But in the instant case, if the deed goes, then entire preemption will go. I have already challenged that deed. That's why I am the necessary party. The preemption application, preemption proceedings which is pending, where I want to add as a party respond.
No, Mr. Counsel, if in any case you succeed in your suit, on the basis of this deed, whoever will get the preemption, he will also be bound by that.
The multiplicity of proceedings would arise. Well, I have
that suit. Why don't you add this person also as a party?
Well, that I have already. They are already in party in that suit. In my suit.
How is your presence relevant here? Because if he is a party there, it will be adjudicated
in the instant suit. The preemption in the lateral proceedings we are going. I have challenged the suit deed. Which is under.
Because preemption is in.
Yes, it's fact. But if deed goes, which is the documents under which they are claiming the opposite party number 1 and
serve and come.
Yes,
difficult.
Already, my lord, I have the 2 proceedings. I have already, my lord, filed a suit and already an FIR. My lord, both, my lord, I have annexed.
This revisional application is directed against an order dated December 17,
expeditious disposal of the title appeal, which is pending before ADJ 1 at Shialda. Lordship, the instant appeal was
This revisional application.
Party number 2, personally, because I was selected as an arbitrator, I don't know anything about the matter. Suddenly I received a copy of the petition. Probably my lord has directed so that service can be effected on me. I can tell you, Lordship, what I know is a counsel who normally appears in arbitration matters, engineer. He telephoned me a couple of years back that, are you agreeable to be an arbitrator? I said, yes, because we know each other. Yes, but do I know your client? No, you don't. You never appear. So very well. I'm said, is there any fighting or other bad things? No. Other side is Steel Authority of India Limited. Very well. There was joint arbitration of the old Act 1940. So I said, very well. And proposed my name. And he asked me a letter so that I have no connection. I have also given that letter. Rest I do not. After several years now, I have received this.
Both the parties appear because nobody is there today.
Correct, but only if I cannot come here.
Not a problem.
I'll excuse it.
If you are there, if you have been added as a party in the capacity of an arbitrator, you have hardly anything to say.
Anything to say. So naturally. Great.
41, my lord. I am for the plaintiff petitioner, my lord. I made an application for revision against the order passed by the learned 12th bench, City Civil Court at Calcutta. Initially, a suit was filed on behalf of the plaintiff on the ground that 2G of the West Bengal Princess Tenancy Act. A third party intervened. My lord, they made an application under section Order 1 Rule 10(2). That application was allowed.
Why?
My lord, partly they are in possession. He may be a subtenant. My lord, they lodged a caveat, my lord. I have already served the copy.
Then I'm making it not today. Let them come.
Yes, ma'am. My day after tomorrow, my lord.
Day after tomorrow.
Both the suit. 141 and 142.
141, 142, পরশু দিনের date.
Day after tomorrow. Grateful.
144, my lord, I am for the petitioners. My lord, there is a caveat. I have already served the copy upon the caveat.
Not today.
My lord, kindly fix the matter. My lord, 7th is the date fix.
Not
The
today, is
point is,
tomorrow.
my lord, the
call,
point is this: the court, though had no pecuniary jurisdiction on this matter, proceeded
Very
with
well,
this.
the other side is not there. Why are you submitting? I'll not be able to take it up. You have a
My
resolution
lord,
today.
kindly fix it.
I've said not today. It means tomorrow it will be taken up. Chalo, next.
145, I'm for the petitioner. There is also a caveat. But I serve the copy to the other side.
Not today.
Day after tomorrow.
Day after tomorrow date kore dichi.
Date pulen.
145 day after tomorrow. এই 144 এ ওনারটাতে একটা অর্ডার লিখে নিন তো উনি চাইছেন একটা ওনার পরশুদিন ডেট আছে।
My lord, 7th is the date fix.
ফাইল তো লাগবেই না, কি করে অর্ডার? Yes, what was your problem?
My lord, the fact is this: though court do not have any pecuniary jurisdiction on this
Why
matter,
do you say it is not having pecuniary jurisdiction?
my lord, kindly come to the plate. My lord, it is at page. It is started from page 17. Kindly come to the pre-hearing portion, page 30.
Yes, 30.
30.
Yes.
My lord, what are the prayers? First, for eviction of a defendant from upon recovery of the license and recovery of the khas possession. Then, for passing degree of means profit. Thereafter, degree for permanent injunction. Thereafter, temporary injunction. Now, my lord, kindly come to on page 30, para 17. What the price has been shown. Suit is valued at rupees 200. 100 for eviction.
Eviction of a license.
Licensee. My lord, eviction of a licensee as per section 7, sub-rule 6, it should be 12 months into the
what? Of what? 12 months of what? License is permission. 12 months of what?
Of the license fee. My lord, this is the law.
Show me.
My lord, I'm showing. My lord, I pencil, it is written something. My lord, 76B2, B1.
Yes. So what will it come to?
Where the license.
What will it come to? You forget about that. What will it come to? What is the pecuniary jurisdiction of the?
My lord, now the jurisdiction. My lord, make this question. My lord, the civil judge junior division had the jurisdiction of rupees 6,000. Now the jurisdiction crop up if all the prayer has been came into effect. It has come For license, 6,000.
What had you done? You had filed an application under
Under
order
7.1, order 7 rule 11. My lord, kindly come to page 30, 4.
Order 7 rule 11 has been rejected.
No, this is the point. My lord, when I have filed an application under order 7 rule 11, immediately they have filed an application under order 6 rule 17. They want to cut down certain prayer, only remain one.
Rightly done.
My lord, this is the wrong. This is the wrong. My lord, unless a court cannot have the jurisdiction to decide any matter, court cannot go.
You serve, law is against you. You serve and
My lord, I show your lordship with this regard. I show your lordship 3 judgments. One is division bench judgment of our court. One is Mumbai High Court's judgment, and another one is Madras High Court judgment. In these 3 judgments, my lord, once kindly go through. First, this Bombay Court's judgment, my lord.
Show us our High Court. Forget Bombay.
My lord,
Let us see
I
what
will show.
Calcutta has.
I will show all the things.
No. Show me only Calcutta.
Calcutta, my lord. It is reported in AIR 1978, Calcutta 133.
Show me.
কপিগুলো কোথায় গেল? Because, my lord, I marked it well kindly. I'm praying for apology, my lord.
No. দেখি
এইগুলো পেজগুলো একসাথে হয়ে গেছে কি করে? সবগুলো একসাথে হয়ে গেছে তো।
রাইট লেট দেম কাম এটা কালকে রেখে দিন নিউ মোশনে
And my lord, with regard to the same, I show
Tomorrow,
your
new
lordship
motion tomorrow.
this judgment also. My lord, once kindly go through this judgment.
এটা ফেরত করে দিন
My lord, once kindly go through this judgment once, my lord. Para 9 and para 4. And I'm praying for apology again, my lord.
Para 9.
9 and 15. This is the Bombay High Court judgment. This is also affirmed by the Supreme Court.
Affirmed by Supreme Court by dismissing SLP or by a reasoned order?
By reasoned order.
Show me.
My lord, can I show you tomorrow, my lord? I will.
Show me because this is not the law that we follow. Calcutta High Court follows different. ধরো এটা ফেরত দিয়ে
My lord, to this.
If an amendment application has been filed, yes, so far as the jurisdiction point is concerned, we shall consider. But if an amendment application is filed, law is that amendment will be allowed, and if that cures rejection of plaint will not be rejected.
My
That
lord,
is the law.
thing is the law.
Whatever may be the thing, I have said that.
Do not have that jurisdiction.
That is
If
a different point.
do not have the
That is a
jurisdiction,
different point. But this point of yours that amendment application has cannot be considered prior to the Order 7 Rule 11 application is not the law.
My lord, unless I get the jurisdiction, how
I have understood that. That is a point which we will consider. The second point is of no use. Don't press the second point. So far as first point is considered, we'll consider it.
My lord.
fixed to the. Uh, But this was that matter, my lord, where your lordship, my lord, sitting with Justice Banerjee, my lord, delivered that judgment of occupational charge of money square.
Yes.
My lord, absolutely applicable. My lord, I read the judgment for numerous of time, but I found that, my lord, although, my lord, I have filed the application under 151, but, my lord, the powers, my lord, has been conferred from 151 apart with Order 39, Rule 10. So, my lord, I'm a little bit confused, my lord, whether, my lord, the revision at all be maintainable or not. Maybe that be so.
Anyways, there is a caveat also.
Thrice, my lord, sir, my lord, this is the fourth time.
What to do every time it is taken up? কালকে নিউ মোশনে দিয়ে দিন এটাও নিউ মোশনে দিন কালকে কি অনেক নিউ মোশন আছে
Lord, I shall also further intimate. Lord, after that judgment, my lord, it has become, my lord, a new, my lord, the issue. But, my lord, recently, my lord, I also get, my lord, a very interesting order, my lord, from the commercial court only because of that judgment. And in any event, my lord, that SLP is pending, my lord, I am keeping watch of that.
Which one was the judgment?
Lord, that money square, my lord.
Money square.
But earlier it was that up to contractual, it can be given. But very recently that Vijay Kumar, Manish Kumar came, that although, my lord, some of the judges was of the opinion that it is 142. But my lord, with Justice Banerjee, my lord, given, my lord, excellent, my lord, observations. And basically, my lord, that interim order must be passed, my lord, in the aid of final order. My lord, prima facie, my lord, the landlord, my lord, is not getting the
benefit of the decree.
And in any event, my lord, suit will be dismissed, the rent would be adjusted. And I shall intimate.
156, I appear for the petitioners, my lord. This is, my lord, director on last week to serve and come back, already served, my lord.
Today nobody is appearing.
Okay,
There is a resolution.
Yes.
Unless both parties are there, we will not.
No, the next date is on 16th of May, my lord. Can we take up-
Tomorrow, day after tomorrow, whenever it is called.
Great.
চলুন, চলুন।
Sixty-one, my lord, I am for the petition. Direction was for service. I have effected service matter. Then
Good, কেউ নেই তো। Not today করে রাখুন আর কি। Not today.
I have served also.
Yes, but
None.
you have a resolution today.
Yes, my lord. Let it be taken.
নিউ মোশন গুলো কল করে দিন, কারণ এক্সপেডিশাস ডিসপোজাল তো টাইম দিয়ে দিয়েছেন, কি করে এখন কল করবেন? ওই টাইমটা আমাদের বরঞ্চ আগে দিলে ভালো হতো। আজকে আজকে তো কেউ নেই। হ্যাঁ হ্যাঁ,
Lordship, be pleased to take up expeditious disposal matter, my lord. I am appearing in item number 194, my lord.
কল করে দিন, আছে যখন করে দিন, আর অসুবিধা কি?
One 194, my lord.
I'm 87, my lord. 187, my lord.
Give your numbers. 187,
187.
187, 194,
232.
My lord, 206, my lord.
67, 167.
So
232.
232.
যেগুলো হয়ে যাচ্ছে সেগুলো হয়ে যাবে, হ্যাঁ, তো অসুবিধা নেই।
In this matter, my lord, the title execution number 1 of 2017 is pending before the learned learned additional civil judge junior division at second court and Diver Harbor, my lord. In title suit passed by the judge, title suit number 95 of 2092, my lord. My lord, I want to draw one attention, my lord. If you come to page number, the last page, my lord, that the regular OP is transferred from order dated 15th November 2025. And since then, my lord, the regular court is lying vacant. So, my lord can.
This revisional application seeks expeditious disposal of title execution case number 01 of 2017, pending before the learned additional
Lordship, in item number 172, I beg to appear, Lordship.
You are there.
Lordship, yes, Your Lordship, I was there.
172 দিয়ে দিন।
Lordship, I secure kindly to appear virtually.
Yes, 172.
So, Lordship, this is an application for expeditious disposal of matrimonial suit number 314 of 2024, pending at family court in charge at Tamlu.
This revisional
Lordship,
application seeks expeditious disposal of matrimonial suit number 314 of 2024, pending before the learned judge, family court, Tomluk, Purbo Mednipur. Full stop. Paragraph, usual paragraph. তারপরে, having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned judge, family court, Tomluk, Purbo Mednipur to dispose of matrimonial suit number 314 of 2024 as expeditiously as possible and preferably within a period of 1 year from the next date fixed, without granting any unnecessary adjournment to either of the parties.
Lordship, may I just indicate one thing? The petitioner is a judge sitting at sitting at Raghunathpur, Purulia. So he has to travel long distances to attend the hearings. So, Lordship, the repeated adjournments and this
I've said without
being on
granting
leave is
unnecessary adjournment.
Yes, Your Lordship. Yes, Your Lordship. If it can be reduced to 6 months, Your Lordship. He is a family court judge at Tamil.
It's a 2024 suit in any case. 8 months করে।
Deeply obliged.
Lordship, item number 220, my lord. Item number 220.
Wait.
My lord, kindly to.
Yes.
Item 220, my lord. It's a expeditious disposal
Wait
application.
Wait for your turn.
Very, very well.
Deeply obliged.
Thank you.
There is even an application is pending for a substitution application. During the pendency of this revisional application, petition number 2 died on 5th March 2026. That's why an application has been filed. Substitution application is in the list, within the list.
Can'ta নেই দিদি, can নেই। ক্যানটা দিন, লিস্টে দিন, তারপরে নেক্সটটা কল করুন। ক্যানটা খুঁজে তারপরে নেক্সট।
Can one.
Ninety-four
194 and 206, my lord. For these two matters, my lord, I am appearing. These two matters, my lord, they are the complaint cases pending before the Alipur Consumer Court, my lord, since 2019. Why I have approached before your lordship, my lord, both the cases were fixed for argument in the year 2024, July 2024. Since after that, my lord, argument has not been done and the cases are yet to be disposed of.
This revisional application seeks expeditious disposal of complaint case number CC 269 of 2022 pending before the District Consumer Dispute Redressal Commission, Kolkata Unit -3 within bracket South. Paragraph. A learned advocate appearing for the petitioner submits that in the said complaint case, the case is at the stage of arguments. Now, in the said complaint case, the said complaint case is at the stage of arguments. Yet, the same has been pending since long. Full stop. Paragraph. Usual paragraph. Therefore, having heard the learned advocate appearing for the petitioner and having perused the material on record, this revisional application is disposed of by requesting the learned District Consumer Dispute Redressal Commission, Kolkata Unit 3 -3 bracket South, to dispose of complaint case number CC stroke 269 of 2022 as expeditiously as possible, and preferably within a period of 1 month from the next date fixed, without granting any unnecessary adjournment by the.
My lord, I am deeply obliged. My lord, in item number 206, my lord,
Wait for a minute. 206 to the.
my lord, the complaint case number is only 270.
এখানে কমপ্লেন্ট কেসটা 270 হয়ে গেছে, বাকি সব সেম থাকে, ঠিক আছে? Yes.
I'm grateful.
CEO such and such stands disposed of. And in Didi 206 টাও হয়। হ্যাঁ, একজনের 220 আছে, ওটা দিয়ে দিন।
Yes, I'm there, my lord. Item number 220.
211. Please give your numbers to the court officer so that it becomes easier for them beforehand. If you give the numbers, by the time yes, why not? It is possible. Please wait. The others who are earlier than that. $802 is what? Motion or contested application? 802 টা দিদি বের করে রাখবেন। 802 21
not 325
224
325
325
and 173.
173.
Yes, early disposal of this suit.
দেখুন দিদি 173
No caveat has been lost. That's why I have not. What? Yes.
কোনটা?
मतलब petitioner number 2 वाला diet वाला on 5th March 2026. That's why an application वाला file, application for substitution.
Then the matter it has to be substituted, then I can hear it.
Thereafter, my lord, thereafter expedite this, my lord.
लिखे नहीं. Can 1 of 2026 is an application for expeditious disposal. 2026 is an application for substitution of the heirs and legal representatives of the petitioner number 2 who breathed his or her his last during pendency of the revisional application. Full stop. The application for substitution is within time.
Yes.
And the heirs and legal representatives of the deceased petitioner number 2 are all sui juris. Full stop. In such view of the matter, comma, can 1 of 2026 is allowed. Full stop. The department shall take appropriate steps to substitute the heirs and legal representatives of the petitioner number 2 as indicated in paragraph 2 of the substitution application being can 1 of 2026 forthwith. Full stop. List this matter on Monday, next Monday.
Yes, great.
My lord, item number 220, my lord, for expedition.
Just a minute. Can dispose.
সোমবার থাকবে, পরের সোমবার।
ও সাবস্টিটিউশন হয়ে আসবে, তারপরে তো এখন তো শুনতেই পারবো না।
In this matter, there's two was filed for declaration of title and permanent injunction in the year of 2018.
This revisional application seeks expeditious disposal of title suit number 481 of 2018 pending before the learned civil judge within bracket junior division, comma first court at Hooghly, comma Chinsura. No, at Chinsura, comma Hooghly. Full stop. Usual paragraphs. Having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket junior division, comma first court at Hooghly to dispose of title suit number 481 of 2018 as expeditiously as possible and preferably within a period of 8 months from the next date fixed without granting any unnecessary adjournment to either of the parties. Next.
The suit is pending, my lord, since 2024, my lord. They had filed an injunction application, my lord. The injunction application is not being heard since 2024, my lord. Although we had filed application for vacating. I mean, if the suit and the, my lord, injunction application can be expedited, my lord.
Injunction application, I'll fix a time frame. Suit, I'll say as expeditiously as possible. This revisional application seeks expeditious disposal of title suit number 996 of 2024, pending before the learned civil judge within bracket junior division, first court at Barasat. My item is 107. Give your names there. Give your items there. They will.
This matter, my lord, the title suit 112 of 2007, my lord. The suit for declaration
This revisional application
and
seeks
permanent
expeditious disposal of title suit number 112 of
Dependent.
2007, pending before the learned civil judge within bracket senior division,
Yes.
second court at Howrah. Full stop. The usual paragraph. Having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket senior division, second court, Howrah, to dispose of title suit number 112 of 2007 as expeditiously as possible and preferably within
But I pay for the matrimonial proceedings pending since 2017 has finally come to the stage of arguments, my lord.
My the cost title, my lord, 56 of 2017, my lord, in the cost title, my lord. But I have it, my lord, due to inadvertence, my lord, I have it. Due to inadvertence, it could not be annexed. But I'm carrying the original, my lord. AJ, my lord, my lord, get to din eta. It to din, my lord. Okay. But it will be third code, my lord. If you kindly see, it was initially before the sixth code, my lord, it's transferred. Arguments, my lord. Grateful. Much obliged, lordship.
My lord, 195, my lord. Yes.
Yes, item number 220, my lord. But this is my second application for expeditious disposal, my lord. Already on January 2023, my lord, there was an order of this honorable court appearing at page number 42, my lord, to dispose of the suit within a period of 1 year, my lord. Despite of that, my lord, the learned court below is, with all due respect, my lord, is giving time every 5 months, my lord. Next date is sometime in August, my lord. If my lord kindly.
Your number 323. 323.
Whereby a coordinate bench of this court had directed the learned trial court to requested the learned trial court to make every endeavor for expeditious disposal of the pending applications as well as the suit, preferably within a period of 1 year from the date of communication of such order. Full stop. It is submitted that despite such order, the suit still remains pending. Full stop. Having usual paragraph, having heard the learned advocate appearing for the respective parties and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket senior division, second court at Barasat, North 24 Parganas to dispose of title suit number 268 of 2013 as expeditiously as possible. What is the stage?
My lord, its evidence has not yet started, my lord.
As expeditiously as possible, preferably within a period of 8 months from the next date fixed, without granting any unnecessary adjournment to either of the parties. Full stop. The learned trial court is requested to consider that the petitioner is not required to walk up to this honorable court again for the same relief. Full stop paragraph. CU such and such stands disposed of.
So grateful, Lordship.
Yes. Yes.
One 195 টা ডেকে দিন এই ফাইলটা রয়েছে 195 Yes, my lord. In this matter, I am appearing for the defendant petitioner, my lord. The suit for declaration and title suit was 2015-536 before the learned civil judge, junior division at Hooghly.
This revisional application seeks expeditious disposal of title suit number 536 of 2015 pending before the learned civil judge within bracket junior division, comma first court, comma Hooghly. Usual paragraph. Having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket junior division, comma first court, comma Hooghly to dispose of title suit number 536 of 2015 as expeditiously as possible and preferably within a period of 8 months from the next date fixed without granting any unnecessary adjournment to either of the parties.
My lord, item number 243, my lord.
Your lordship, in item number 196, I beg to appear on behalf of the petitioner.
Wait. It be difficult like that. People who are personally present in court, first let theirs be over, then we'll take up online. যারা কোর্টে আছে তাদের আগে নিয়ে নিন তো, যারা বাড়িতে বসে আছে ওদের একটু ওয়েট করতে হবে।
173. Yes. In this matter, I am appearing for the defendant plaintiff. Petitioner, suit for declaration and permanent injunction in the year of 2021. Civil Judge Junior Senior Division at Hooghly, first court.
This revisional application seeks expeditious disposal of title suit
Your lordship, it is a matter of 1008.
preliminary decree was passed, Your Lordship, on 2012 at page 25. Thereafter, Your Lordship, kindly don't take in other way. In 2016, Advocate Commissioner was appointed. Your Lordship will see, due to his laches, the case is delayed because he failed to complete the survey and file a report. It's very unfortunate, Your Lordship. Kindly peruse the Your Lordship, learned court is not taken into consideration. It's still awaiting from the report of the erstwhile commissioner. What to say, Your Lordship, they are not. He have paid all the fees and everything has been done. Despite of that, he is doing nothing. Your Lordship, I cannot ask for refund and another file. These are very difficult. Only this much. 2016 he was appointed. From order 32. The certified copy order I have annexed. Order number 32, it will reflect that he was appointed in 2016. First court civil judge, senior division only. On 29th, passed on 29th day of August 2012. Partition Commission was appointed on 13th of January 2016. Yeah, at order number 32, certified copy. I think it is 13th of January. By the parties, Your Lordship. Fees paid by the parties. No, 13th of January. No. I'm grateful to Your Lordship. Deeply obliged.
I am for the petition. No, expeditious disposal of the partition suit. pending since 2014. The petitioners are the plaintiff. The preliminary decree has been passed in favor of the petitioner. Till then, no final decree has been passed. Petitioner filed an application that is pending. My lord. Application file a put up petition for petitioner file and put up petition for final decree. Partition suit. Fast code Baharampur. Cost title, madam. Kindly see my passport Baharampur. Grateful. 28th of February 2017. 28, 2017. Grateful, Lord.
Like 234, my lord. Appropriate and necessary direction, my lord. Matrimonial suit number 719 of 2021, my lord. My lord, twice the suit was fixed ex parte against the husband, my lord. And my lord, the issues has not been framed, my lord. Till date, issues has not been framed, my lord. 20th May 2026 is the date fixed for issue. Framing of issue, my lord. Pending since 2021, my lord.
$241, my lord, I am appealing for the petitioner. I am praying for expeditious disposal of a partition suit, my lord, filed in the year 2013, my lord.
100. But I am for the petitioner. The application for expedited clearing of the title suit number, TS 159 of 2016, pending in the Court of Learned Civil Judge, Junior Division, Second Court, Contai, District Purbo Medipur. Yes. Contai, District Purbo Medipur. This is a senior. The suit for declaration, Junior Division. Chief of the plaintiff is completed, evidence. No, 6 months. If possible, 6 months.
May be permitted, my lord. Item number 243. Item number 243, my lord. My lord, it's not audible from the other end, my lord.
Yes, what is your problem? Tell me.
My lord, it's a matter of expeditious disposal, my lord. I'm humbly seeking order.
Expeditious disposal of what?
Of the title suit, my lord. I'm the defendant over that in the title suit, my lord. I've taken out an application under Order 13 Rule 4 for vacating of the injunction order which I'm suffering. That was taken out in the year 2023, my lord, on 11th of May 2023. Since that it has been pending.
Want expeditious disposal of the application or the suit?
My lord, both, my lord. My lord, after the application.
This revisional application seeks expeditious disposal of title suit number 192 of 2023, pending before the learned civil judge within bracket junior division at Barasat, North 24 Parganas, as well as an application for vacating interim order of injunction under Order 39, Rule 4 of the Code of Civil Procedure, 1908, filed in connection with such suit. Full stop, paragraph. Usual paragraph. Having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket junior division at Barasat, 24 Parganas North to dispose of title suit number 192 of 2023 as expeditiously as possible. Now, title suit age to dispose of the petitioner's application under Order 39, Rule 4 of the Code as expeditiously as possible. The objection to your Order 39, Rule 4 has been filed.
My lord, no objection was filed.
As expeditiously as possible and preferably within a period of 2 months from the next date fixed, without granting any unnecessary adjournment to either of the parties. Full stop. The learned trial court is also requested to dispose of title suit number 192 of 2023 as expeditiously as the business of the learned trial court would permit. CO 636 of 2026 times disposal.
Grateful.
হ্যাঁ, না এখনো তো সময় হয়নি, যারা বসে আছেন ওনাদের তাহলে শুনেন। আর ওনার কি আছে, ওনার 300 কত আছে?
325. There is no caveat and
দেখি ওনার যারা আছে, যাদের caveat নেই তাদের করে দিই, শুধু এটা পরে আবার
find out the record. I will say something. A restitution of conjugal right has been filed by the husband before the Shialda court. Wife appeared, written statement has been filed, and matter is contested. All on a sudden, husband went to the Barasat court and filed an application under section 12 of the Guardians of Wards Act for custody of the child, 5 years old boy, and obtain an ex parte order. Against that, petitioner came before your lordship. According to the order, there is the ex parte order.
300 কত বললেন?
325.
Yes.
Obtain an ex parte order to see his son. But according to me, the order is not any wrong, but the attitude of the husband, he is an advocate of the. He is the advocate of the Barasat court, Barakpur court, and he with a cunning attitude. When a pending application before the Shialda court, if he want to custody of the child, file an application under section 26 or 38 of the Special Marriage Act or 26 of the Hindu Marriage Act. Instead of, he filed separate application before the Barasat court and obtain an order, and landed court also been passed the said order. This is well settled principle of law. A wrong forum pass a good judgment. That judgment itself is the nullity. My contention is, the husband, if he has come before the landed court with a clean hand, he maybe file an application.
According to you, that court does not have jurisdiction.
According to me, when a pending application regarding matrimonial dispute before the Shialda court, where is the specific provision under section 26 of the Hindu Marriage Act or section 38 of the Special Marriage Act? He did not file separate application under section 12 of the Guardians of Water Act before the another forum and obtain an ex parte order. If your lordship kindly come to the Page 24. This is an application under section 9 of the Hindu Marriage Act. This is the restitution of conjugal right application. And next page, the written statement filed by the wife on 15th May 2025. And therefore, the Domestic Violence Act has been pending, section 23 pending. We are not concerned about the Domestic Violence Act. If your lordship,
You serve and come. I'll not pass an interim order. It's only visitation of child, father is always entitled to meet. Because these are all technical considerations. Let the child have both the parents.
Very well.
This revisional application assails an order dated August 12, 2025, passed by the learned additional district judge, fast track court -1, Barakpur, North 24 Parganas, in Miss Case number 175 of 2025 within bracket Act 8, whereby the opposite party has been permitted to visit his minor son twice a month within the premises of Barakpur Subdivisional Court. Full stop. The petitioner, learned advocate appearing for the petitioner, submits that such an application has been filed with a malafide motive only to harass the petitioner, as much as the opposite party could have got the same relief by filing an appropriate application in the pending matrimonial proceeding between the parties before the learned additional district judge, Sialda.
matrimonial suit number 74 of 2020.
Full stop. It is submitted that the petitioner it is submitted that the matrimonial suit, being matrimonial suit number 74 of 2024, instituted by the petitioner, is prior in point of time.
No, instituted by the opposite party.
Instituted by the opposite party is prior in point of time, and the opposite party could have filed appropriate application in the said suit itself, praying for the same relief. But how can he get custody under 12?
Custody of in my favor.
No, Act 8 case has been filed by the opposite party again.
Yes.
So that case, by way of an interim measure, he could not have got that.
No,
He wants custody. Act 8 case is for
not custody, only see the child.
Section 12 is only for visitation? No.
No, there is a custody, but section 25 of the.
But he wants custody also. That is why this application has been filed.
He prayed for custody of the, but
So this
in the interim measure only see.
That is right. That is right. But his application under section 12 is you can't say that it is not maintainable. So what is wrong in this order at the first place? Because if you say that section 12 also could have been filed only before the Sialda court, that is a different thing.
My contention is that when an application and there is an appropriate relief on the basis of that, he ignoring that provision and suppression the fact, go to the another court and obtain an order on the basis of that another provision. This is only my that even that order also passed without service any notice, well, totally ex parte order.
Yes. The petitioner shall serve a copy of the revisional application along with notice on the opposite party, intimating the opposite party that the matter shall be taken up next on June 11, 2026. The petitioner shall file affidavit of service to that effect on the returnable.
But under heading new motion.
Next.
Date puller.
May I have my lord's kind leave to mention item number 196?
My lord, I am on behalf of the
Yes,
petitioner.
yes. Please wait.
No.
Please wait. Not like this.
But there is a dispute between the parties, and in the agreement there is a clause of arbitration. And the petitioner, here respondent herein, kindly come to the page 318, third volume, my lord. Third volume. In a nutshell, my lord.
318.
318.
Yes.
The Honorable Justice Shomen Sen passed an order directing the to appoint an arbitrator.
Yes.
My lord, kindly come to the next 321. The award has been passed.
Award is passed. Yes.
Yes. They have challenged. Oh, file ta down, I'm not going. They have challenged the award. My lord, challenged the award before the Honorable High Court at Calcutta. My lord, page 353.
Award under section 34. Challenges under
Yes.
section- Yes.
354, my lord.
354 is
353. 353.
353 is the order.
The order passed by the Honorable High Court, my lord. They filed the without an application. It is submitted, Mr. Ghosh, learned advocate, appearing on behalf of the petitioner that
No,
this
but
court does not have any
353
jurisdiction.
34 was dismissed.
34 is dismissed without any leave to file afresh.
No. It was only dismissed on the ground of territorial jurisdiction. Leave
My
is
lord,
not required.
territorial jurisdiction, my lord, Justice Shomen Sen passed an order directing the appointment of arbitrator. The petitioner herein, respondent herein, without any application, filed, verbally submitted before the Honorable Court, and according to application AP number
So
346.
what is the point of challenge now?
I am challenging order 23, my lord. Without leave of the court, they filed another application before the
Order 23 will not apply here because that is for withdrawal. This is not for withdrawal.
This is an withdrawal. Stand rejected, my lord, on the territorial jurisdiction.
Not on the ground. Withdrawal is different thing. Court holds stands rejected on the ground of lack of territorial jurisdiction of the court. It is not withdrawal at all.
My lord, territorial jurisdiction, when the court is, my lord, first order is 318, my lord. Honorable Justice Shomen Sen passed an order.
That is different.
Appointed the court having the jurisdiction, my lord.
If you are aggrieved by this order,
My lord, they filed the file. My lord, kindly come to the, my lord, page 371. Matter is pending before the learned commercial court, Rajarhat, my lord.
Yes.
My lord, we have preferred that order dated this is withdrawal and adjustment of the suit. Whether the court is satisfied.
What is the order which is now under challenge in this revisional application?
Yes, my lord. I am challenging the order dated page 390.
Page 390.
I filed an application challenging the maintainability of the suit.
That has been rejected.
That has been rejected, my lord. But I have the prima
Will
facie
you
case.
take your seat? Let me go through the order.
My lord.
Where was the agreement entered into? Where is the agreement?
Agreement, my lord, kindly look into the arbitration volume 1, my lord.
Where was the seat for arbitration?
Seat for arbitration before the here on Calcutta.
No, not the venue, seat. There is a difference between seat and venue. What is the seat which is mentioned in the agreement? Show me the agreement.
Agreement, my lord.
Does it mention any seat?
My lord, kindly come to the volume 1 too. Page 41 is a tender, 42. Next এখানে আছে agreement, my lord, page 114. Agreement.
Where is the arbitration clause?
Arbitration clause in the agreement, my lord. There is an arbitration clause in the agreement, my lord. 1 minute. Agreement.
You don't have it.
My lord, kindly look into the page 160, my lord. They pray for the appointment on arbitrator. Page
No,
160.
I want to see the seat of arbitration. Where is their section 34 application? Show me that. Where they have
Section 34 application, my lord. Kindly look into the I annexed with my petition, my lord. দাঁড়াও ভলিউম 3 তে না ভলিউম 1 এ আছে ভলিউম 3 তে থাকবে কেন ফার্স্ট annexure. My lord, page annexure A, page 15.
Page 50.
No, 15.
15.
This after withdrawal, they filed the same before the district judge.
Just a minute.
Page 15.
You are appearing for the opposite party.
Yes, my lord.
You are appearing for the opposite party in this matter. How is the commercial court having jurisdiction in regard with regard to this arbitration matter? Because in your pleading, you have said that the entire arbitral proceeding, the contract, everything happened within the jurisdiction of this court, this honorable court.
Yes.
So how can you go to the commercial court at
After the, my lord, after the enactment of the Commercial Courts Act, firstly, we filed it before this court under section 34 to set aside the award. Number one. During this period, commercial courts have been enacted. For this, the district judge of the respective courts are in charge of adjudicating the matter. Section 34. We filed it before the
how does that court have territorial jurisdiction? You answer this point only.
Section 30, as per the Commercial Courts Act, there are several courts established under the Commercial Courts Act.
If the this court dismiss the section 34 application on the ground of territorial jurisdiction.
No. My lord, give me 2 minutes time. This court has dismissed this our application, which we have filed under section 34 for the lack of the territorial jurisdiction. Then, where is the jurisdiction then? Jurisdiction falls under the district judge.
How? That is my question. How? How does it fall within that district judge? Show me. Was the seat of arbitration within the jurisdiction? Part of contract was executed. Where? How?
Yes.
Where is the pleading in your section 34 petition?
Our agreement was constituted under the...
Show me from your section 34. Don't make submissions in the air. Please show me from your section 34 petition the pleadings wherefrom I will be able to gather that the court had jurisdiction. Show me from section 34.
No. Actually, my lord, we filed it before this court. This
court now dismissed it.
Yes, dismissed it for the lack of territorial jurisdiction.
So the other court where you have gone, that has territorial jurisdiction. Where is the material to understand that the court has territorial jurisdiction?
Sir, as per the agreement itself, this falls under the...
Show me that.
Agreement. There is agreement also. I am showing you. Agreement
দিয়েছো ইয়েতে সেকশন 34 এর অ্যাপ্লিকেশন আমি
Okay,
অ্যানেক্স করে দিয়েছি
all right.
এটা অ্যানেক্স করে দিয়েছি
Lord, there is the agreement.
Sir, show me from the papers.
Actually, my lord,
argument will not do. You please show me from the papers.
Lord, allow me for some time, for 1 day or 2 days, as because yes, agreement that is in the page number 120 of their application in volume number 1.
That shows nothing. Show me the clause. I want to see the clause wherefrom I will be able to ascertain that the court where you have approached has jurisdiction.
No, my lord.
No?
The point is, this agreement falls under the DGM MW Kolkata jurisdiction. Have you got it in the page number 120 of their application?
Sir, this is not going to help you. You please understand the query of the court and then answer. Please see your section 34 application. From
Yes.
your section 34 application, please satisfy me that you have made out a case for the commercial court Rajarhat to entertain your section 34.
Okay.
Show me from that.
Okay. Section 34 application তুলে দিয়েছেন? দেখুন, তো আমাদের কলিং নাম্বার 15. No, the volume কত? 1. Volume 1. Volume 1 দেখেছি তো। What is the section 15? কত নম্বর কথা আছে? 15. Yes, yes. Sir, our application is annexed with their application that is in the page number 15.
I have seen your application. You
Yeah.
show me the paragraphs. The paragraphs only show why this court had jurisdiction. But despite this court having jurisdiction, according to you, please come to page 36. I am making it clear.
Yes.
Please read paragraph 28.
Yes. Your
read it to yourself. No need to read aloud. Please read it to yourself. And show me how this paragraph will help you to show that the commercial court at Rajarhat has jurisdiction to entertain section 34 application. Or if you can show some other paragraph, please show that.
My lord, in para 28, we filed it before this court. We dismissed this for the lack of the territorial jurisdiction. The matter is then, we filed it before the commercial court.
Sir, before the commercial court at Rajarhat, how? That is what I want to know.
I think it is, my lord, it is as per the Commercial Courts Act. After the,
Cannot be as per the Commercial Courts Act. It has to be, somebody has to have jurisdiction. Merely because Commercial Court Courts Act is enacted, you will go and file it there. That cannot be the law. Show me that it has jurisdiction over the subject matter, and if it has jurisdiction over the subject matter, then how was the agreement entered into?
kindly, my lord, kindly allow me 1 or 2 days, then I shall give you reply.
This revisional application assails an order dated January 5, 2026, passed by the learned judge May, 18th of May.
This is 18th of May, my lord.
New motion দিয়ে দেবেন
18th of May.
Grateful.
Grateful.
1, 2, 3.
Please give your names.
আমি সরিয়ে দিচ্ছি।
Appearance টা দিয়ে দাও, appearance.
দেয়া হয়ে গেছে।
Grateful, my lord.
526 ওনার 526 টাও ডেকে দিন দিদি।
My lord, kindly takes 821. 821. I'm waiting for the queue. 821.
Please wait, please wait. 526 নিন। একটা সিরিয়াল করে নিন, সিরিয়াল করে নিন, যারা যারা আছে তাদের করে দিন।
35 under the
Please, please write, everybody, please write it on a piece, one piece of paper, please everybody write so that it is easier for us. একটা বড় কাগজে সবাইকে দিয়ে দিন, সবাই লিখে দেবে, তাহলে সুবিধে হবে। একটা কাগজ দিন। All of you, please write it on at one place so that it is easier for them, because
Already handed over.
we are not going serially, so they will be facing trouble in pulling out the files.
দেখি একটা কাগজ আপনার নাম্বার বলুন 266
It is easier if we go serially. Now, since we are going in a haphazard manner, it is becoming difficult for them.
Malad, I am waiting on. Malad, I am waiting on online.
Yes, Mr. Mato, you are in your comfort of your home. So those who are there physically present, we are giving preference to them.
No, Malad, so far my matter is concerned, there is a caveat, therefore it cannot be taken up. But what I am praying, Malad, if your lordship kindly fix a date so that on that date, Malad, matter may be taken up.
Which matter?
473.
473.
Yes, ma'am. CO number
far off.
4513. Yes.
There is a caveat. Very well, we shall.
There's a caveat, but I am only praying
I'll
for
come back to
fixing
you,
a date.
Mr. Mahato. Yes, yes, sir.
Mal, I'm grateful.
My matter is 526.
Ki dilen didi? Whose matter is this? 235? Yes.
It is for expeditious disposal of the matter.
This revisional application seeks expeditious disposal of money suit number 398 of 2024 pending before the learned judge, second bench, City Civil Court, Calcutta. Paragraph. Having regard to the nature of the order proposed to be passed, prior service of a copy of the revisional application along with a notice is not being directed. However, the prior service along with a copy of the revisional application along with a notice on the opposite parties.
There is only one single opposite party.
Opposite party is not being directed. However, the petitioner shall remain obliged to serve a copy of the petitioners shall remain obliged to serve a copy of the revisional application along with a copy of revisional application along with a copy of this order on the opposite party within a week from date. Follow? Paragraph. Having heard the learned advocate appearing for the petitioner and having perused the material on record, this revisional application is disposed of by requesting the learned judge, second bench, City Civil Court at Calcutta to dispose of money suit number 398 of 2024 as expedient. What is the stage?
My lord, they have filed if your lordship looks into the bunch of the orders, they have now not filed the written statement even after 2 years. The defendant, I'm the plaintiff over there. And they have now filed the Order 7 Rule 11 application. Most interest after filing Order 7 Rule 11 application. In that application also they are not appearing. They have been asked to show cause also. That show cause also they have not submitted.
As expeditiously as possible and preferably within a period of 1 year from the next date fixed without granting any unnecessary adjournment to either of the parties.
My lord.
CO such and such stands disposed of. With the above observations, no costs. Yes.
My lord, I mentioned the item number 253. This is also for the expeditious disposal order.
Please wait, sir. Those who are physically present, let me finish their cases, then we shall take.
Okay, thanks.
Very good.
Lord, in this matter, my lord, I am for the petitioner. My lord, the OP number 6 died. My lord, we have taken steps. My lord, let that application be allowed. My lord, can 1 of
Petition is there.
2026. My lord,
And one. Ache.
the OP number 6 died on 11th of May
Taken it.
2025 and we filed on 8th of August.
Died on?
Died on 11th May 25 and we filed on 8th of August 2025.
It is beyond 90 days.
My lord,
But
within
within 120 days.
just 2 days left.
10-1 of 2025 is an application for substitution of the heirs and legal representatives of the opposite party number 6. Full stop. Comma, who breathed his last on May 11, 2025. Full stop. Paragraph. Since can 1 of 2025 has been filed within time and the heirs and legal representatives of the opposite party number 6 within brackets since deceased, comma, whose details have been mentioned in paragraph 2 of the said application are all sui juris, comma, therefore, can 1 of 2025 stands allowed, full stop. The department shall take appropriate steps to substitute the names and other details of the heirs and legal representatives of the opposite party number 6 within brackets since deceased as indicated in paragraph 2 of can 1 of 2025, 25 or 26, can 1 of 2025 forthwith, full stop. List this revisional application in the monthly list of June 2026.
Lord, may I serve the substituted, Lord, the person, Lord, who are Lord, included, may I serve?
There was direction for service on the other opposite party.
Already appeared.
The petitioner shall serve the substituted opposite parties in the meantime.
Item number 821 is expeditious disposal. If my lord kindly takes my lord. 821.
Please wait, Mr. Chakraborty. Mr. Bhattacharya, please wait. Let the persons who are physically here, they have braved the court. Let them be heard first. Chalo, next.
Lord, in this matter, Lord, I filed a suit. Lord, I filed a suit for recovery of possession. Lord, I filed a suit for recovery of possession on the ground of building and rebuilding. I filed an application, my lord, for measurement of the property, my lord, since in any way if the suit is degraded, my lord, I will have to, my lord, hand over the possession in respect of the tenant. My lord, it is only done that reason, my lord, I filed, my lord, learned court, my lord, dismissed on the ground of fishing of evidence. Only for measurement of the tenanted property. Suit for building and rebuilding. DW is about to, my lord, to be completed. And my lord, if anyway,
but your own suit will be stayed if I pass.
In any way, my lord, suit has been, lord, the interim order has been refused, my lord, on the earlier occasion.
Why don't you serve and come?
Lord, I have served. Lord, they are, my lord, not appearing. Lord, difficulty is that. Lord, kindly keeps it, my lord, any day. Just, my lord, for measurement of the property. On the ground of building, rebuilding.
Likhene. None appears for the opposite party. Full stop. Mr. Rai, learned advocate appearing for the petitioner, submits that none appears for the opposite party to pore likhben. Mr. Rai, learned advocate appearing for the petitioner, submits that the opposite party has been served. However, comma, none appears for the opposite party. Full stop. List this matter as motion on May 12, 2026. Next.
Lord 1694. Lord, I am for the opposite party. Lord, here what happens
Opposite
is that,
party, I will not pass. Let the petitioner be there.
Lord, the difficulty is that, Lord, the suit has been stayed, Lord, for 4 months.
Very well. The opposite party is not there. That will
Lord,
be
entire Lord, thing has been covered by a recent judgment of the Supreme Court.
very well. You mention it.
Lord, I have mentioned, Lord, many times, Lord, but your lordships have not allowed. Lord,
What is the problem?
suit has been dismissed. My eviction suit was for forfeiture of lease. Now, my lord, lease has been expired. I want to bring that amendment.
Very well. Opposite party, you are
1960 suit.
right, but the petitioner is not there. It will not be right. If you had been the petitioner, the carriage of proceedings would have been with you. I would have passed now.
My lord, I have a short matter, my lord. Item number 395 of today's list. my
Yes,
lord.
बाकी काদের কি কি আছে
526 my matter, my lord. A suit for specific performance of contract filed by opposite parties. Suit degree
পাওয়া যাচ্ছে না। আচ্ছা, যারা অনলাইন আছে তাদের কি পাওয়া যাচ্ছে? একজন 196 দেখা যাচ্ছে।
My item is 827.
My is 821, my lord.
821, 827. Please wait because files are being pulled out because
Only my difficulty, it was initially item number 60, then it had become 660, now it had become 827, my lord.
Can't be helped.
Lordship kindly fix any day, subject to lordship convenient, any day. 827. It was 60, then 660, then 827. I am not asking, my lord.
My lord, item number
827.
We have item number 253, expeditious disposal.
एक तो बोलते थे
196 টা call.
my lord, item number 1072, my lord. My lord, can you give me direction to serve notice to other side?
Wait, the file is not before me. I'll not be able to pass.
And
Yes,
my lord,
196.
fix the date before
827, my lord, file is here, my lord. 827.
196, Lordship.
Mr. Jena,
I beg
please
to-
wait. 196. Who is appearing?
Lordship, I beg to appear on behalf of the petitioner, Lordship. Here the suit has been filed by the predecessor of the respondent in the year 2020, Lordship. The injunction application was being heard, Lordship. It was last heard on 20th November of 2024. Then the hearing of the injunction application has been deferred, and till date, Lordship, the injunction application has not been heard out, Lordship. I have suffered an order of injunction, Lordship. It has been passed in favor of the plaintiffs, opposite parties. I have
You
been
want
suffered with an order of-
expeditious disposal of the injunction application.
I want, Lordship, the expeditious disposal of the application, and since the suit is pending since 2020, Lordship, the suit for partition, I am also seeking a direction to expeditious hearing of the suit as well, Lordship.
This revisional application seeks expeditious disposal of title suit number 416 of 2020 pending before the learned civil judge within bracket senior division, Howrah.
Second court, Lordship.
Second court, Howrah, as well as an application under Order 39, Rule 1 and 2 of the Code of Civil Procedure, 1908, filed in connection with the said suit. Full stop, paragraph. ওই usual paragraph যেটা সার্ভিসের একটা বললাম। এখানে হ্যাঁ, এই expeditious disposal এ একটা থাকছে যে having regard to the nature of the, ওটা সবেতে থাকে। Next, having heard the learned advocate appearing for the petitioner and having considered the material on record, This revisional application is disposed of by requesting the learned civil judge within bracket senior division, comma second court, comma Howrah to dispose of the pending application for injunction under order 39 rules 1 and 2 of the court as expeditiously as possible and preferably within a period of. You have filed your written objection to the
Lordship, hearing has commenced
within
in
a period of
2024.
1 month from the next date fixed, without granting any unnecessary adjournment to either of the parties. Full stop. The learned trial court is further requested to dispose of title suit number 416 of 2020 as expeditiously as possible and preferably within a period of 1 year from the date of disposal of the said application for injunction. CO 325 of 2025-6 stands disposed of with the above observations, no costs.
I am grateful, Lordship. Only one indulgence, Lordship. I am led by Mr. Rohan Banerjee in this matter.
Mr. Rohan Banerjee is not even there virtually.
Lordship, was there, Lordship. I am led by him.
নামটা দিয়ে Mr. Rohan Banerjee.
I am grateful, Lordship.
Very good. Cholo.
My lord,
Lordship,
900 also.
if my lord kindly takes item
900 is also.
821. 821.
না যারা আছে তাদেরই তো নেবে আমরা
Kindly takes my item number 821, my lord.
Please let the files be there, Mr. Bhattacharya. The files are not all files are not like that. Na? You have to
900, my lord, also, my lord,
Matters are not
for
being called
expeditious
serially.
disposal. 900 is also for expeditious disposal. Item 900.
আর কিছু পাওয়া গেছে
253 also expeditious disposal, Lordship.
May I have a lordship leave to mention on matter that item number 395 is a very short matter, my lord. I will not take
395
much
টা বের
time
করে
of
দিন
your
না
lordship.
39 হ্যাঁ ঠিক আছে ওনার 395 বের করে দিন এগুলো উপরের দিকে আছে সেগুলো বের করে দিন
Lordship, item number 250 also the expeditious disposal matter, Lordship. Item number 253.
Wait, sir, please wait.
I have two matter, 526 and 1072. 50
Please tell them.
526 আর 1072.
But 262 টা কি আবার
Petitioner before your lordship. Round of default and reasonable requirement. In connection with the said suit, my lord, I filed an application, my lord, for insertion of 2G.
262 is for what? For extension of interim order? Interim order expired when?
Two occasions, my lord, I served copy upon the opposite party, but none of them, my lord, appeared. So also kindly have a look at the service.
Yes, but today
Because I am suffering, my lord. My suit has come to halt. Eviction
yes,
suit,
but I cannot dispose it of today in their absence.
very short matter, my lord, kindly have a look at
Even
this.
then, today there is a resolution of no adverse order. How do you expect me to pass an order disposing of the revisional application?
Very short matter, only 2 lines.
Mr. Haldar, it is not the question of short or long matter. You have taken the resolution. You are asking to violate it. Eta ফেরত দিয়ে দিন.
My lord,
It is remaining in the position. You next day I'll dispose it of. Not today.
only not today, my lord.
Well, not today. Yes, it's there and under the heading extension only. It will be taken up. It's next.
526, 526,
1072. 395.
My lord, item number 1072.
Please don't make submissions till I have the file. It's no use. I will not understand. আর কিছু আছে ফাইল দেখুন
526 আর 1072. 526. No, sir.
My lord, I think, my lord, 473. My lord, I think, my lord, item number 473 file is not required because only for fixing a date. I have
Really?
submitted before lordship that
Wait,
there is a caveat. Mr. Poti is there.
473 দিদি
My lord.
473 টা একটু মার্ক করে নিন এটা ইয়ে
মানে সিমিলার প্রেয়ার মানে 827 8 সিমিলার প্রেয়ার 827
মানে
আর 827 এটা চেম্বারে এসে কথা বলে নেবেন 827
Similar with regard to 462 and 677, my lord.
1072 same pair মানে
1072 ওনারটাও নিয়ে নিন 107
Similar pair with
wait Mr. Bhattacharya
1072 item number
473 1072 yes
462 and 677. 462
77 yes Mr. Jena, what was your number?
827 my lord. It was 60 then 660.
That history Mr. Jena, please forget.
Anyway my lord, I have some urging your lordship, kindly fix any day my lord.
That history
Subject to your lordship convenient my lord, I am not pressing your lordship.
এই আইটেম গুলো চেম্বারে কথা বলে আমরা ডেট ফিক্স করে নেব কবে নেওয়া হবে
I am grateful my lord.
I am grateful to your lords.
and my lord item number 526 file is not here my lord later
নিয়ে নিন যদি থাকতে পারেন আর এখানে কেউ এক্সপেডিশাস ডিসপোজাল আছে সেগুলো যদি
900 item 900 my lord.
821, my lord. Expeditious
900.
disposal 821.
900 also my lord.
800 and all is difficult
900 my lord.
900 difficult
Expeditious this.
Item number 253, lordship.
এনারটা কল করে দিন না 300 কত আছে অনেকক্ষণ ধরে
ফাইলটাই তো পাওয়া যাচ্ছে না
800 900 খুঁজে পাচ্ছেন না যারা পাশে আছে কাছে আছে তাদেরটা দিয়ে দিন
if my lord my matter is if file is not available my lord kindly give and date 526 and 1072
এগুলো নোট করে রাখবেন ফাইল দেখে আমরা ডেট দিয়ে দেব দেখি আর্জেন্সি কি রকম আছে তা
526 1072 526 1072
ফাইল খুঁজতে বোধহয় 4:30 বেজে যায়
yes that's why my lord give another date just today I'm giving the number 526 আর 1072 526 1072 but not today is not required
actually it is difficult
yes,
because
yes.
They maintain a flow
lots of files is
suddenly
there
900 800 difficult
Lordship 253, lordship.
253 253 কি পাওয়া যাবে দেখুন দিয়ে দিন No mentioning now. I'm not yet rising. Please wait. देखिए yes 253
Yes, lordship. I am for the plaintiff petitioner. This is the suit for partition, and in the said suit, Order 7, Rule 11, and Order 12, Rule 6 is pending since 29 January 2025, and suit is 2022.
This revisional application seeks expeditious disposal of two applications under Order 7, Rule 11 and Order 12, Rule 6 of the Code of Civil Procedure, 1908, filed in connection with title suit number 1011 of 2022, pending before the learned civil judge within bracket senior division, 7th court at Alipur. Full stop. Usual paragraph. Having heard the learned advocate appearing for the petitioner and having considered the material on record, this revisional application is disposed of by requesting the learned civil judge within bracket junior division, senior division, comma 7th court at Alipur to dispose of the two pending applications under Order 7, Rule 11 and Order 12, Rule 6 of the Code as expeditiously as possible and preferably within a period of 2 months from the next date fixed without granting any unnecessary adjournment to either of the parties. Next.
Lordship.
Disposed of.
CO 32
bundle 2 Lumination 2
4270 amount 395. Here, what happened, my lord? The husband filed a divorce suit in Hindu under Hindu marriage act. Wife is the petitioner before your lordship. Wife filed a section 24 application for alimony pendent alike. Now, the learned court passed the order, final order in section 24 application. That is the order impugned here. My lord, kindly, I want to draw your lordship's attention to the last page of the application. That is the last page of the order also.
Yes.
May I read the order portion? The second para. The opposite party husband is directed to pay rupees 10,000 per month to the petitioner wife towards alimony pendent alike. The effect of this order shall be from the date of passing of this order.
You want it to be from the date of application.
Date of filing. That is the one. That is the.
This revisional application is directed against an order dated August 28, 2025, passed by the on the returnable date.
I'm okay. One submission, another submission is that, my lord, the husband petitioner now trying to withdraw his own max suit. If also filed an withdrawal application.
That you can challenge there before the learned trial court. I cannot pass any order here in their absence.
I'm.
My lord, may I be permitted to mention item number 929? Item number 929, my lord. I am seeking only, my lord, extension of interim order. My lord, kindly consider that, my lord.
Extension of interim order দিয়ে দিন ওটা 929
Well, matter is appearing under heading contested application. Well, I am
929 extension এ দিয়ে দিন you did not mention it for extension you mention it for extension it will appear under extension mention it today give it application I'll take one day I have not been regular here sometimes in division sometimes in Jalpaiguri so if the court is regularly here for a month I can plan my affairs it becomes difficult otherwise I'll be taking up application one day thank you